And Jean, if you're saying something to me, I cannot hear you. No, okay. I said Representative Dauphin is here, and I think Representative Linehan is here as well. So well, I think I'm going to go ahead and get started because I know that we have some of the speakers who have time crunch. So good afternoon, everyone. This is Senator Saud Anwar, one of the Senate co-chairs for the Children's Committee. We will call our public hearing to order. And I just wanted to thank everyone who has signed up to talk about and share their perspective with us. And I know Representative Linehan is in the middle of another meeting. Representative Dauphin, do you want to say anything at this point?
Thank you, Senator. I just want to welcome everybody, and we're looking forward to maybe a little shorter hearing today with, I think, 29 people set up. So let's get it started. Thank you.
Okay, perfect. Thank you. And Representative Wielander, do you want to make any comments?
Thank you, Senator. I am really looking forward to hearing the discussion today. I think there's a lot of very important topics, and I think I'm really pleased and proud that the committee is taking them up. So I'm looking forward to the discussion.
Thank you so much. And with that, I see Representative Linehan is in the, just for everybody's benefit, right now you will probably see multiple different representatives come in and out of meetings. I know that everyone is in 2 or 3 meetings, if not 4. And that's why we're trying to shuttle between different Zoom meetings at this time. And that's why you may not see everybody. And as soon as we have some of the other members and leadership join in, I will be having them say a few words. With that, our first speaker on our list is Representative Meskers. Representative Meskers is traveling, so he's about to take a flight, and we wanted to make sure that he gets an opportunity to speak. So Representative Meskers, thank you for waiting, and welcome to the committee.
You know, thank you very much, Senator Anwar. You and I wrestle over insurance and various issues, but I have to tell the work of this committee particularly, I think it's so meaningful, so important. I know you've had a tough time of it wrestling with the issues of children's mental health. I want to personally thank you for with the coordination with the various leagues on the neck guard issue in the prior meetings. I think those are important issues in the safety. And I want to speak today towards the raised bill 5240. I've been a resident of Greenwich for 25 years. I have a number of friends who are active in the hockey field, parents of my age. So now their children in their 20s and 30s. And they reached out to me, and that was one of the subjects of conversation was about the tragic accident in Greenwich. And I want to thank you for coordinating between the independent schools and the public schools about working on getting a neck guard in place. So I want to do is speak towards this act, establishing a task force for the protection of youth and intramural and interscholastic athletes. I can't think of a more important item than this. If you look at the history of what happened with the neck guards, I think it's a simple oversight by various interscholastic, inter-regional leagues, and the conversation about safety protocols. So I'm hoping that this bill will work on a collaborative basis just to work out a baseline of safety protocols for our students so that everyone, you know, is cognizant of what those safety protocols are, whether they decide to follow all of them, but it becomes an advisory where people consciously decide whether it's the type of helmet, the type of mouth guard, the type of various safety protocols. I'm hoping that this bill will lead us to figure out an embracing groundwork to form a framework of recommendations. And the only thing I would ask in addition is that the independent schools, when this project is finished, that the independent schools are brought along on a consultative basis, because my thought is that going forward, it's probably the safety protocols need to be reviewed on an annual basis. so that everyone proactively decides what fits their league, what fits the nature of the protection they think is adequate for their scholastic group or their athletic leagues, but that they're all aware that we've begun to look at this to establish a baseline. I think, our charge is to protect our constituents, and the most vulnerable of those are our children, and we turn them over to our programs, our athletic departments, with the full expectations that we have a holistic approach. And I think this bill will get us there. So I really want to just speak in support of it and thank you for the work.
Thank you so much, Representative Meskers, for your testimony. And I'm so sorry about the accident in your town, and our condolences to everyone in the entire town. I know the entire town has been grieving, and this was very difficult during the other conversation that we have had to learn about the experiences of the friends and family of one of the students. I know my co-chair has joined in, Representative Linehan. She was actually there all the time, but she was multitasking. So Representative Linehan, you have done a lot of work behind the scenes on this as well. So please go ahead.
Thank you very much, Senator. And thank you, Representative, for coming here and talking about this and bringing this to our attention. When we first heard of the tragedy, I think all of us really thought, okay, neck guards, we need to have them. It's a really great point now that we need to protect all students, and we need to really know the science behind exactly how we do that. And that's why I'm just such a huge fan of the bill that you put forward, that you asked us to do. And I see that moving forward, and I know that we've gotten a lot of people who were for that. So I want to thank you for the great idea. And I think that this bill ultimately really should move forward. So I'm with you on that. So thank you very much for being here. And thank you to you, Senator.
Thank you all very much. And I have to run to catch a flight.
Okay, safe travels. Thank you. And that brings us to our next speaker, which is our Commissioner, Commissioner Durantes. Thank you so much, Commissioner, for being here. And I understand you have a team of your DCF with you, which would be phenomenal to just hear your thoughts on some of the bills. So go ahead, Commissioner. We can't hear you.
Two mute buttons. My goodness, not just one. So good afternoon, Senator Anwar, Senator Kelly, Representative Linehan, and Representative Dauphinais, as well as the distinguished members of the Committee on Children. Here today is Vanessa Durantes, the Commissioner of the Connecticut Department of Children and Families, and I will be discussing three separate bills. The first, we would like to thank the committee for raising the department bills, and I'll start with SB 206, an act concerning the Department of Children and Families recommendations for revisions to statutes concerning children. This particular bill asks that the consideration be given related to our procedures on background checks. Under several existing statutes, entities such as child caring facilities, child daycare facilities, youth camps are required to ensure that background checks through DCF's Child Abuse and Neglect Registry are conducted prior to hiring an employee who works with children. In the interest of time, I will just reference the fact that this committee has heard several bills related to background checks in the previous sessions, and this one is a technical fix to make the process more efficient. In 2021, DCF conducted 200,000 registry checks. This led to a delay at that time, as you are aware, of providing registry checks quickly for hiring employees, and that created a little bit of a bottleneck. The existing law permits the department to conduct a registry check for some entities without DCF having physically obtained the release of information from the prospective employee. So, for example, such checks may be performed by the Office of Early Childhood on prospective child care facility employees and for school districts on prospective school employees. They will obtain the actual physical release and then attest to the fact when requesting the background check be done by DCF. So we are requesting that change. The coordination and administration of education for children and youth in this very vulnerable population is a key component of their success and future well-being. The department has collaborated with the Juvenile Justice Policy Oversight Council to put forth not only this recommendation, but the recommendation involving statutory changes of the administrative oversight for education for children being seen as under the JJPOC. The next raised bill, SB 205, is an act establishing Children's Mental Health Day in Connecticut. The Department of Children and Families supports SB 205, an act establishing Children's Mental Health Day in Connecticut, and we want to thank the committee for raising this bill as well. The bill designates May 26th as Get Outside and Play for Children's Mental Health Day. We would respectfully recommend that an entire month be dedicated to children's mental health. The importance of children's mental health, based on what we've seen in these public hearings and all of the forums, is a significant one. The COVID-19 pandemic has exacerbated what is already a growing mental health crisis among the youngest members of our population. So we wholeheartedly support this particular bill and respectfully ask that it be increased to a mental health month to increase awareness and access. The last would be raised bill HB 5243, an act concerning adult sexual misconduct. The department thanks the committee for the opportunity to share our comments regarding HB 5243, which is an act concerning adult sexual misconduct. Section 4 through 6 of the bill requires DCF in consultation with the Department of Public Health to develop a bystander training program and an appropriate interaction with children training program. It requires DCF and the State Department of Ed to provide the training to school staff, teachers, and administrators of any high school in which students who take Connecticut School Health Survey have been the victims of sexual assault or misconduct by an adult. It also mandates that all school coaches complete the training as a condition of employment. We are instead proposing to work in collaboration with SDE and the Department of Emergency Services to further enhance our mandated reporter training modules to include bystander and appropriate interaction with children training. Connecticut has a comprehensive list of mandated reporters, as you know, across multiple disciplines who are required to report suspicion of child abuse and neglect, and training on these topics would be offered by the DCF Academy for Workforce Development, where thousands of mandated reporters each year receive in-person and/or online mandated reporter training. The training is available to all mandated reporters. However, school personnel are required by state statute to receive the training prior to hire and annually every 3 years. Section.
That's just a time notice.
Thank you. Just lastly, Section 8 of that particular bill pertains to SDE's ability to revoke, suspend, or place on probation a person with a teaching certificate or permit or authorization who has been substantiated for abuse or neglect. So there are other sections of this particular bill that we would like to continue to talk about and continue furthering our discussion as to ensure continued timely, appropriate investigations of these persons. And with that, I will accept any questions from the committee.
Thank you so much, Commissioner. Before we take the questions, I know you have 4 or 5 other people who are in the team who are just with us and part of the conversation. Everybody's been enlisted to have 3 minutes, and I'd rather have you just outline some of the other things that you are going to outline on the issues with that bill, number 5243.
Thank you very much, Senator. I would. Thank you. Section 10 requires DCF in collaboration with SDE and OEC to develop a protocol and checklist for investigations conducted by boards of education or child care service providers as a result of alleged abuse or neglect by school or child care employees. We are concerned about this particular language as it is DCF's statutory responsibility to conduct child abuse and neglect investigations in collaboration with law enforcement if necessary. We are concerned that this language may be interpreted to shift the investigations function and to the responsibility to the school or child care provider in certain circumstances. This would be contrary to existing mandated reporter laws and could conceivably impede the integrity of an investigation or even delay the timely child protective service response. We currently conduct those investigations jointly. And then lastly, the department conducts investigations with OEC in collaboration cooperates with the State Department of Ed during investigations of school personnel. Written investigation findings are provided to both agencies, and DCF established centralized educational professionals unit. If you recall, a few years ago, we stood that up in response to some questions about the timeliness of our investigation. So our EPIU is specifically designed to investigate employees of childcare facilities and school personnel. And so, Senator, those are the other two areas of concern that we wanted to raise here.
Thank you so much, Commissioner. And I think those are very valid points. We are taking notes, and I think we'll look at your testimony and look at how we can address that. With that, I know my chair is interested to talk, and our ranking member is also interested to ask clarifying questions. Or so who should I start with? I think
You can start with
Dauphin
Rep.
had raised her hand.
Dauphin. Senator, please start with
Okay,
Rep. Dauphin.
Yeah. Representative Dauphin's hand was raised earlier, so please, Representative Dauphin, go ahead.
Oh, yippee. Thank you. Thank you, Commissioner, for coming on. I just wanted to clarify some information with regard to the database you spoke about on SB 206. I'm trying to understand a little bit about that. I know the DCF registry is used, and is that automatically given to a certain individual applying for a job? Is that how that is? Can you just clarify that? I'm sorry.
Correct. So there are two decisions that happen when someone is investigated. One, is it substantiated or not? And then the second decision is whether or not they'll be placed on the Child Abuse and Neglect Registry. And so when someone, an entity that is looking to hire someone to work with children, sends a background check to DCF, what they're asking for is whether or not this person is on our Child Abuse or Neglect Registry. And so that registry is what's being referenced in that particular bill.
So if it's substantiated, can you just describe the difference between substantiated and then being put on the registry so I can understand that?
Absolutely. The substantiation speaks to whether the allegation is a reasonable suspicion of abuse or neglect, and a substantiated finding is that there is a significant evidence to support that not only occurred, but that this child is has been deemed a victim. The registry decision looks to the perpetrator and our assessment as to whether or not they pose a potential risk in the future to other children. And that's where you get into whether or not someone should be working with children or not be permitted to because they are on our registry.
And another question, a follow-up, that decision is not made by a court of law, correct? They have not gone through due process. This is simply just through you.
Correct. It's a statutory distinction that we have been given as the state's Child Protective Service Agency to make those distinctions, and that is not that doesn't have to go to court now.
So someone who has not gone through a court of law would be put on that registry depending on what your decisions are.
Certainly, yes. Every single investigation that is substantiated is required to make that second finding of whether or not they pose a risk to children in the future.
Okay, thank you very much. I appreciate it.
Thank you for the question.
Thank you so much, Representative Dauphin, and Madam Co-Chair.
Thank you very much, sir. So hi and welcome.
Hello,
How are
thank you. Thank you very much. Well,
I've been seeing a lot of you guys lately.
and we love it. We love
I'm
it. You know, I just
sure.
have to, no, I really do have to say, Representative, that 265 people expressing an interest in children's mental health and children's behavioral health makes my heart proud, because
I agree.
we can get to all of this by just continued hearing perspective of everyone. So just thank you for all you all do.
You're absolutely right. So I'm so glad you said that. Thank you. A couple of things I want to just get out of the way, the easy benefit members. Background checks. So the changes that you're requesting to be more efficient, they're not going to be less thorough. They're not going to lessen the effectiveness or the protection of children, correct?
Not at all. The request, the paper release will still be gathered by the entity requesting the background check, and they will be there. And that particular entity, whether it's a school or a child care provider, will attest to the fact that they have that release, and that we will actually be able to turn the background checks around quicker by not keeping, what was that, 200,000 background pieces of paper at DCF. So I think that will create a better efficiency in that particular process.
Great. I just wanted to make sure that my committee members understood that. I want to say first, thank you for thinking about May being Mental Health Month. That's exciting. I like that idea. So we'll move forward with that too. But I wanted to really get into the nitty gritty of 5243. So as you know, this committee has been really, I don't even just want to say dedicated. The word is determined, determined to put forth legislation that protects children from abuse and neglect, and very specifically sexual abuse. And so I will say that I'm really glad that your testimony really didn't, there was really nothing negative. It's constructive criticism, which tells me that we're in this together, and I'm thrilled about that. So I just want to understand your testimony, because unfortunately I didn't get to read it before we came on here today. So to talk about sections 4 through 6, the bystander training and the appropriate interaction training for children, you wanted that to be a collaboration with SDE and DESP, right?
Yes, because our current mandated reporter laws speak to the professional who is in their professional capacity caring for kids. A bystander in this particular instance may not be captured under that, and we don't want to miss people, but we also don't want to, kind of extend the net so far out that we undo the intention of this particular recommendation.
All right, great. And, again, we've had some discussions about this, and I've also spoken with Ken Meisegland about this at length over the years. So I think you guys understand where we're trying to go with this. But essentially, it's the fact that, especially over the last few years, last year even, what have we had 4 or 5 particular cases where there is a teacher, a coach, someone involved in the lives of children in a professional capacity who has sexually abused a child. And we have learned through news reports at this point, because I don't think anyone's gone through a trial yet, but that there was some belief that this was going on. There were whispers, there were rumors. What we're trying to get at is ensuring that anyone within the sphere of that child in their professional capacity will understand when it's appropriate to stand up, right? Because we watch all these, read these reports, we watch the shows, and they talk about, they were interviewing parents the other day on the news who said, "Oh, I never let my kid go near that teacher because, we always knew in the community that that's what that teacher did." And so that's why the bystander training is so important. And we want to empower people to stand up and say something. This is a natural extension of what we passed last year regarding the grooming information. So given what we did there, I just want to make sure that there's an understanding throughout our committee, but also to you, that this training is that extension that tells people what to look for and then empowers them to stand up when they think something might be amiss. And it's always better to say something than to not say anything, even if you're not sure. So is that essentially, if we call it bystander training in the statute, we're hitting that?
One of the suggestions that came out as I was talking to my team is that there's a current curriculum that mandated reporters go through either online or when a member of my staff goes to a particular school district and delivers it in person. What we were thinking is that there's going to be certain mandated reporters like teachers and education professionals who could use kind of a supplemental. So what does that look like that, every year we can expect that they do this core curriculum? And then what appendixes can we say are also at their disposal and that can easily be secured by an administration to give to their entire, workforce to be able to really reinforce the statutory requirements in mandated reporter training. But hey, this is what we've learned over the years investigating these types of situations that you need to be, that you need to know a little bit more more about. I will ask though, one of our assistant legal directors, Kate Dwyer, is one of our policy experts here and has done a lot to really unpack what this would mean from a statute standpoint. And I'd like to invite Kate into this conversation. Kate, can you kind of fill in the blanks as to what we were looking for specifically in the recommendation related to bystander training?
Sure. Thank you for the question. It's nice to see everyone today.
you.
So with regards to bystander training, what we had been suggesting was actually an amendment to the existing mandated reporter training, which is offered by our Academy for Workforce Development. And that is mandated by statute for all school employees who are mandated reporters. It's also made available to any mandated reporter through our website, through virtual modules. And what we wanted to do was add that information into that training so that employees would be getting it on the front end and on those regular periods when they're receiving the training, rather than waiting until, as the bill is written, for there to be a revelation that a student has been the victim of sexual assault. So
Yeah, I think that's written. You have a really, really great point. And so I just want to thank you for that, because the way it was written, it was supposed to be on the front end and then a refresher if there's an issue, right? So it should be both. So when we change that to both, you'd be in support.
I will defer to the
That a yes?
commissioner.
Absolutely. Anything that we can do to enhance mandated reporter training. And, you all were very instrumental in kind of lifting up the failure to report statutes that we now have incorporated when we find that there are entities that were obligated to report and didn't. So I think the more we can educate the public on what to look for and how we do that in a more consistent basis, the better we are in terms of the people who are responsible for the care of kids. But we don't want to be so prescriptive that we leave out people unintentionally.
Yeah, thank you for that. And that's why this is a partnership.
Mm-hmm.
And I think just to pick up on that one last piece that Attorney Dwyer said, Representative Linehan, if your vision was train people up front and then on an ongoing basis, that's exactly what our current mandated reporter training does. Because as far as school employees, you have to take that training prior to hire, and then at certain intervals in your teaching career as refreshers. So I think building this new part right into our existing structure to us makes a lot of sense in collaboration with SDE and DESP to design it.
Okay, and so, which is great. And the bill is written, or the hope is it's written this way, that essentially the first training needs to be in person. The yearly updates can be online, but if there is an issue in your school and we come in for the refresher, that has to be in person. Did you recognize that in the legislation? And if not, we would want to change it to that.
Attorney Dwyer, I know you've gone through all of these with a fine-tooth comb. Did you see that distinction, or is it something we need to get back to the chairs on?
If you can bear with me for a fraction of a second, I actually have the language here. So, because I don't want to go with my recollection, that's never.
Same here.
I trust it. I trust it. While she's looking, Representative Linehan, can I also add and make a little correction to a response that I gave to Representative Dauphiné?
Of course.
Representative, you had asked the question related to the court involvement or the court oversight of registry placement. And my team has reminded me that I should have also given the clarification that there's also an administrative appeal for anyone who is on our registry to say to the department, can you consider removing me because it will impact my ability to care for children in my professional capacity. And that appeal can go all the way to the Superior Court. So I wanted to make sure that you knew the steps related to coming off the registry if the person disagrees or their circumstance change over the years.
Yeah, and just to back up what the commissioner is saying, Representative Dauphiné, also, I believe that there's something like, it's not just an appeal once and then you're done. She did say it goes all the way up, but I want you to know there are numerous incremental steps that get in front of different people's eyes. So we've been through this in this committee before. This is honestly, to me, the best system I've ever seen for someone who disagrees with being on a registry. And it gives them the most ability to get off and appeal so many times. To see if they can get the answer that they're looking for. If you ask me, I think it might be a little too much, but that's just me. But you guys know how I feel about this. So, but yes, okay. So Attorney Dwyer, were you able to?
Sure, I am ready. Thank you. And also thank you, Commissioner, for that clarification, and Rep. Linehan as well. And I did pull up the language. And so in looking at refreshing my memory on the language, Section 5 of the bill requires the department to develop the training. It allows the department to enter into MOUs to provide the training, but I think that the cadence of the training isn't clear in the language as written. What is clear in terms of when it needs to be provided is in Section 4, where it talks about how when the survey that's administered to all of the high school students reveals that one of the students in the school has been potentially a victim of sexual assault or misconduct, then we have under the bill a duty to go in and provide the training. But otherwise, I think, again, the cadence isn't quite clear in the language that I'm seeing as written currently.
Okay, so we'll make sure to get together and hammer that out. So it has the language that I want with the understanding that you need. And we'll work that out. So thank you very much for that. And then I want to talk about Section 8 to revoke, suspend the license of someone with a substantiated case. So I imagine that at some point there's going to be pushback from teachers on this. And so this is kind of where your expertise, I think, is really, really important. And I guess my question for you is, are there times when, because of and I hate to say it, and I don't mean to sound anti anything, but because of a union issue, there has had to be a teacher staying in the classroom, even though there was a substantiated case of abuse?
I would say that there are times across the board in our decisions to substantiate that a person is not placed on the registry. Less likely if we have substantiated against an education professional. I believe it's fair to say, if I ask my legal folks to tell me how often there is a substantiation without an associated registry placement, but it can occur.
And I don't know if anyone wants to jump in there. So would it be more effective without being too tough on someone who might have a wrongful accusation or a false accusation somehow, to then say, if you are on the registry, then you're revoked and suspended instead of a substantiation?
That would be consistent with the rest of the statutes associated with our investigation of education personnel. I think it makes it cleaner and consistent with what we have been doing related to the reason for the registry placement. Because if you recall, in the past, way back when I was an investigator, when you got substantiated, there was an automatic placement on the registry. There was no separate response to, have the department ask and consider their future potential for being a risk to children. And so now, because we have the registry consideration, it requires that the social worker, along with their chain of command who approved the investigations, ask first the question of substantiation, and then secondly, whether or not the person should be on the registry. And so they're very different thresholds.
So what amount of time passes between when it's substantiated and then someone's put on the registry?
Oh, that's within the 45 days of the investigation. The decisions happen separately, but within the context of the disposition of an investigation.
Concern. But if the members of my committee could listen intently and see if there's some people who have suggestions. If an adult within a school system has been accused, I don't want them near kids until we figure it out. That's
So that's a different decision-making point of an investigation involving an education personnel. The accusation, just by virtue of the report being made, typically requires through SDE and the school district to make an administrative decision to remove that person from a classroom, say, or from what their responsibilities are while we are conducting the investigation. Once we've conducted the investigation and render our decision related to the substantiation as well as the registry placement, they have another decision to make related to whether or not they will, they're able to resume their job. If you recall, one of the concerns that school, either the teachers unions as well as the administrators at the school had expressed to us, is that it was taking too long for us to finish our investigations. And they, just by virtue of the allegation, people were kept away from their responsibility of that classroom for too long. So we lifted up the education professionals unit, which revolutionized that. It kept the investigations very contained. And so we can move those along rather quickly to make the decision if the initial allegation has been unfounded and the person can get back in. So the decision to remove someone from the classroom is typically done up front as soon as the allegation is made. And it looks like Attorney Dwyer has something to add to that.
I completely agree with everything the commissioner just said. I did just also want to draw attention to the fact that there is existing law under our mandated reporter statute. 17A 101B, for example, does require the department to notify a school principal or the head of a school when we receive notification that there is an alleged abuse or neglect in the school. And then the school in turn has to notify the child's parents. And then there's another law that requires the schools to suspend an individual when they're notified that our investigation has concluded and that the individual has been placed on the registry. So that's all, again, within the mandated reporter structure of existing law.
So here's where my heart is happy, because we wrote that law and we passed it in 2017 or 2018. And it's good to know that you are just pulling that off the top of your head. So thank you very much. I really, really appreciate that. But I guess what I'm getting at is, so do you guys believe that the law is sufficient enough now to ensure that people are taken out of the classroom if there is an accusation that needs to be investigated? So I guess, Michael Williams, you have your hand up. Do you have the answer to that?
See, Deputy Commissioner Williams has the structure of EPIU underneath the care line under his purview. So he probably is the best person to answer that.
Hi, good afternoon to all of you. And absolutely, we are assured of that. We communicate regularly with superintendents of schools whenever there's a report of abuse and neglect that comes in. The length of time it takes to investigate that is determined by the actual alleged perpetrators' rights to secure union representation. Most districts require union representation to be there before we can question them. And most districts, they do put their personnel out on leave during the process, which then complicates the time factors even more, because now we have to organize the actual interview with the personnel, with their unions, coordinate that. Sometimes they even have attorneys sitting in the process as well. And then when we're done, we issue our disposition. And here's a nuance to this. Some school districts have a threshold to say, if you're substantiated, you're terminated, while other school districts threshold is if you're placed on registry, you're terminated. So
But
once
that's done locally?
Yes, that's their
And is that
determination.
is that in their union contract, or is that
It's
through
the
the Board of
policy
Ed?
of, no, it's the policy of the Board of Educations of the local districts, what their threshold is that they decide. And for a good number of them, a substantiation alone is in their policy a cause for a termination. And of course, the individual have the right to appeal. And while they're going through the appeal process, they're not in the classroom or not at work. They're out on administrative leave by their district. And the final disposition from the appeal is given to the superintendent and that Board of Ed, and they make the decision based on that.
So I very much like that. And well, I just think perhaps we should be codifying that into state law so we could take it out of the hands of districts. So we don't put them in the position where they have to do that, where they could just say, sorry, it's state law. So I like that, and I'll look into that.
It may be a slippery slope, but I
Well-
think it warrants more conversation because of the distinction between the threshold for substantiation and the criteria for registry placement. There are examples that will probably make that a lot clearer if you want to talk more about why the distinction of between the two. But I'm glad he clarified that and what he has seen. There have been some districts who've chosen the threshold that's much lower.
I think it would be good to know what districts have chosen and kind of look on each side. But I have to say, and this will come to no surprise to anyone who knows me, it's important that we err on the side of caution and keep people away from children who can harm them. So moving on, for my last set of questions was section 10 that you talk about, the protocol for investigations. I think we need to be a little bit clearer on the intent so you can help us get us there. I don't believe that schools should be taking over any of the investigations. I think it's more about when there's the rumblings, when there's the rumors. What I am told from educators is then there is an investigation to determine if DCF should be contacted because it's just rumors. And I think we're trying to get to the point where, we have to stop people from sitting on their hands. And so it goes hand in hand with the bystander training in my eyes. And so we just wanted people to be empowered to speak up. So I have been told that there are some superintendents who, and I heard from one superintendent who actually does this. So it's not that I'm working off rumor, but that it was, if there were those rumors and rumblings, that he would then investigate to see if it's just gossip or what have you, and then determine to call you. So that's that investigation I'm trying to get at. Does that make sense to you? And does it change your testimony in any way?
I think it's a little bit more than semantics, but our first reaction was to the word investigate, because investigation is what we are statutorily obligated to do. And there's a certain set of expectations that we have when we conduct those investigations. And I can tell you that having conducted these investigations myself, there's a very different way that that being trained can talk to a child and their witnesses. That's very different than someone who has either made up their mind that this happened or made up their mind that it hasn't. And that may taint an investigation one way or another and make it more difficult for a neutral investigation to occur by the entity that's statutorily required to do so. So we understand the spirit of wanting to really squelch those either rumors and get the school's leadership involved in making sure they know who's in their building. And if there's a concern about someone, whether or not it's enough to call us. But I reacted very strongly to investigation. So you think about one of those investigations that there's a long-term employee that everybody loves, and the investigation sounds something like, Mr. Smith wouldn't hurt you, would he? And those type of leading conversations and ways to talk to children are things that we guard against. So I think we were reacting to investigation and who actually conducts the fact-finding type of spirit of what you were trying to get to.
I think ultimately there are two parts of this bill that can get to where I want with this without even saying the word investigation. And that would be including something like that for administrators in the bystander training on how to deal with rumors and rumblings. And then the second would be something that was not in your verbal testimony, at least, was the extension of the statute of limitations on failure to report. I think that when people realize that that they have, that they're going to be responsible for this one incident much longer than they're currently responsible for knowing about this one incident, I'm hoping that that's going to get people to act and step up. Do you think that that might have that effect? Oh, you're muted.
Yes and no. And I give the caveat that although we have very strong failure to report laws here in Connecticut, there's also the opposite effect from what that could do. So when there were several high profile school investigations, and particularly those that had actions taken related to failure to report, what we got was a deluge of reports so imagine a needle in a haystack, and the needle is what we're trying to get to, but everyone is reporting way more than than that reasonable suspicion threshold. And so there's a both and response to that particular thing. You know what I'm thinking as we're talking, and my team is going to have a fit because I've gone off script, but in sexual abuse investigations, we have something called a minimal facts kind of curriculum of which questions can be asked before an investigation that will, render us a decision whether one way or another to schedule the forensic interview and those types of more engage. And I wonder if we could work to really come up with a minimal facts type question or curriculum for administrators to get to the spirit of what you're asking in terms of not to influence the investigation one way or another, but providing guidance on that. I haven't fleshed that out, and this is totally just me talking off the top of my head, and my team is going to kill me. But I'm thinking as you were saying that, are they? Oh, good. I'm
okay.
looking at them. They're wonderful. They'll tell me if I've gone too far, but.
Ken, I see you've got your hand up. Is there something you want to throw in there?
Sure. I was going to say something very similar earlier. That the bar to report an allegation of abuse and neglect, what we ask mandated reporters to establish is, do you have a reasonable suspicion an act of abuse and neglect has occurred? And if you can say, yes, I have a reasonable suspicion, we're asking you to call. I think, Representative Linehan, what you're trying to get at is, what if I'm a mandated reporter and I'm hearing things, and I don't feel I'm at that reasonable suspicion? Can there be some guidelines, some structures on how we can assist mandated reporters on some activities they can do so they don't cross the line to do an investigation, but it informs them to get to that reasonable suspicion threshold, in which time they know, I have enough, now I need to make a report. And I think when the commissioner gave the example of sexual abuse interviews, and we stop at the minimal facts, that's the spirit of, I think, what we're trying to understand here. And I think what really threw us was the word investigation. So I think in concept, we're saying the same thing about informing mandated reporters, building this into their skill base. It's the language and how we get there. I think we need to.
Okay, perfect. And so, I think that you guys really get where I'm going. We've been working together on this stuff long enough, so obviously we'll be working on that moving forward. Ken, get ready to hunker down. We got a lot of work to do, but I think that we'll get there. And Attorney Dwyer, thank you, because you're going to be really instrumental in this as well. So thanks in advance.
You're welcome.
Okay, cool. So
Thank you.
with that, is there? Oh, I'm sorry, I'm not sharing this one. I'm just going to put on mute.
Oh no!
Thank you. No, I
can.
forgot. No, thanks. You're all good. Thank you very much, Senator.
Well, okay. With your permission, Madam Chair, can I clarify a couple of things with you, Commissioner?
Absolutely.
When somebody is substantiated, are they automatically on a registry?
No, that was what I was explaining earlier, that the substantiation is one threshold, and then the registry is the second decision that must be made at the disposition of an investigation. In the past, the substantiation automatically was the registry decision, and that has been separated.
So let's say there is a teacher or instructor who actually has been substantiated. He or she could easily go to another facility or another school to be able to get a job or another place, and because they are not in a registry, there's no way of knowing if that person is a threat or a concern. So how do we close that loop?
So the fact that the person is a threat or a concern to potentially harm children in the future is the threshold for the registry decision. Typically, a substantiation is centered around this specific incident that occurred and whether or not we have enough to meet the criteria for substantiation. It doesn't necessarily carry over to their potential for future harm of all kids. And the reason why that was separated out is because there are circumstances, and particularly, and one of the things that I said earlier, but I can repeat for clarity, is that particularly in the education professional space, it's likely that when we've reached the substantiation, more often than not, the registry is also attached to that. But there was a reason that we separated those out. Attorney Dwyer, do you have an example? And I can't think of one off the top of my head where we would have a substantiation without the registry inclusion. Michael, do you have one?
Yeah, the most common one is whenever, particularly in high schools, students get into a physical altercation and teachers try to break it up. They get in the middle to break it up. And in so doing, one student may felt like the teacher was more aggressive with them and restraining them to break up the fight, and as a result caused them to be injured, and go and tell the nurse or someone that the teacher did this to me. The nurse has to call it in as an abuse and neglect report to us. We have to investigate it. And in our investigation, it may be determined that in the attempt to break up the altercation, it did happen as reported. The teacher accidentally may have harmed the child. So we substantiate that it did happen. But then we have to say, is this teacher now a threat to children everywhere or in any capacity? And then we say, no, he's not a threat, or she's not a threat to children. We're just substantiated that the allegation that was made that the child was harmed during the altercation by the action of the teacher unintentionally is substantiated.
Okay, this is helpful. Go ahead, Commissioner.
No, I was just saying that's a really good example. Whoops. I don't know why this is. Can you hear me?
Yep.
Okay. Yeah, that's a great
hear you.
example of the distinction between the two decisions. Because in the past, that same person who was trying to protect the safety of that classroom intervened, a child was scratched in the process, and now their livelihood has ended because there's a substantiation before we separated out the substantiation and registry decision.
And can I also ask, at that time, what are the protocols for communication with the family, but also support to the victim?
Yes, absolutely.
And are there opportunities in that aspect further legislatively?
Yes. Right now, when the allegation is made, the superintendent or the head of that particular school, we're talking now just about educational professionals, but there are other, types of investigations that we conduct, obviously. But in the education space, the statutory requirement is a notification to the head of that particular school and the parent of the alleged victim of such allegation. So the parent knows at the start and the parent knows at the disposition involving their child. I do think that there has been some concern about who else needs to know about the disposition of that particular investigation. So other children's parents in that particular classroom, that's a slippery slope. And I believe that was an area that caused some concern in the past.
So are there legislative opportunities there?
Attorney Dwyer,
strengthen that, or
where do you see any holes related to our current statutes on substantiation and registry placement?
I think that off the top of my head, I can't think of any gaping holes. I think it all depends on exactly, as the commissioner was saying, there's that tension, right, between protecting the privacy of the individual who has the allegation against them and also protecting the children families in the school. And so, there is already that notice requirement in law when there is an allegation that the immediate family needs to know. And then there is the requirement in law when the investigation is completed and a school employee is placed on the registry, we make a finding that they belong on the registry, that person needs to, that the superintendent is expected to suspend that individual, pending their own personnel investigation. But I think beyond that, whether there are policy, the policy decisions would really be one for this committee as to whether they want to broaden those individuals who would get notification. Again, in doing so, potentially subjecting the person who is the subject of the investigation to less privacy. Again, I think there's a lot of considerations. I can't think of anything off the top of my head, but would be happy to be involved in further conversations if that would be helpful.
Thank you so much for that. And I wanted to also clarify something that Commissioner, you may have mentioned. Your view is that anytime there's a rumbling, rather than trying to address this within the district, within the school system, it should go directly to DCF, because you would come as independently and also train individuals who do this, and statutory are required to do this. Is that fair?
The clarification is that the threshold for calling in a report is reasonable suspicion. And sometimes schools get kind of, nervous about what that reasonable suspicion is. And, when I talked about the failure to report impact, sometimes they will say, I'll just report it to save my job. And that doesn't necessarily help us really determine if there was indeed reasonable suspicion. The other thing, when we were looking at the spirit of the way the bill was written, and it was talking about doing an investigation to determine whether or not DCF was going to be called, we felt that language was a little bit too similar to what we actually do. And so in the exchange with Rep. Linehan, I kind of suggested that maybe we come up with a very short, what's called minimal facts. That's what we have in sexual abuse investigations, that kind of gives the administrators at the school some guidance as to what you can talk about. Our mandated reporter training right now has a lot of suggestions around that, but we could definitely be a part of a conversation that makes that a little bit more clear.
And the reason I ask this is that essentially in every case that I've heard, and when you listen to the details of it, the child has complained to somebody within the system, and there was no follow-up, and that went on for a little while, and till it got way much more significant than it needed to be. And that's the point, is that it's almost like there is an embarrassment around this, and there is a lack of recognition at times. It needs a little different mindset with some specific training that DCF has individuals who have been through it. And not every board of education and superintendent is given that level of training, if you will.
I absolutely hear your concern there, but I can tell you, as someone who has conducted hundreds, if not thousands of investigations, either myself or that I have supervised, I can tell you that sometimes that information that the child may have today in and of itself may not be enough to give us information to be able to determine whether or not that person has abused or neglected that child. Cumulatively, though, enough of those little incidences have sometimes resulted in an investigation that you can look at and determine that, there's a pattern of behavior that is very concerning. But, the isolated statement in and of itself sometimes does not rise to that threshold. And, we have to determine, where the tipping point is in our threshold for accepting a report. And we have a very standardized set of tools that we use to be able to be very consistent on that have been worked on and normed across the country.
Thank you. Thank you so much for your testimony, and thank you for your help in guiding us through the process and bringing your collective wisdom of the department to help us be in a better place. And we will continue this conversation offline to make sure that the legislation that Representative Linehan is working on at the committee working on, we are in the best place for protecting our children. Thank you.
Always. Thank you very much, Senator. Thank you, Rep. Linehan. Thank you to the committee.
Thank you. The next on our list is Commissioner Beth Bai and members of the Office of Early Childhood. We wanted to thank you for being here and thank you so much for your patience to work with us at this point. So Commissioner Bai, there you are. How are
here
you?
I am. I'm great. How are you?
Excellent.
Good to be here.
Looking forward to learning from you.
Yes, well, I just learned a lot from my colleague, one of my favorite colleagues, Vanessa Durante. So I don't know as much as she does on these issues, but I'll do my best, and I have a great team with me today. So good afternoon, Senator Anwar, Representative Linehan, Senator Kelly, Representative Dauphins, and distinguished members of the Committee on Children. My name is Beth Bai. I'm Commissioner at the Office of Early Childhood. I'm here to testify concerning HB 5243, an act concerning adult sexual misconduct. Section 10 of this bill proposes to require the Department of Children and Families to consult with the State Department of Education and the Office of Early Childhood in the development of a protocol and checklist that would be used by local or regional boards of education and providers of child care services when investigating allegations of child abuse or neglect by employees. As currently drafted, this bill suggests that child care programs will be responsible for the investigation of child abuse and neglect allegation when this is a statutory responsibility of DCF, which I think Commissioner Durante's just covered, and I think you get. Staff of child care centers, group homes, and family child care homes are mandated reporters, and therefore they're required to report to DCF as soon as practicable, but not later than 12 hours after they have reason to suspect or believe that any child has been abused or neglected or is placed at imminent risk of serious harm. The OEC frequently reminds child care providers of their obligations to make a report to DCF immediately upon suspicion of abuse or neglect, rather than waiting for results. And I think Ken Meisel-Glan spoke to this, that is their responsibility. It's not to do the investigation. It's if they have suspicion to do their own, to report it. And we, working with DCF programs, do training. This is mandated, so we really stress that. As currently drafted, this bill has a potential of causing delayed reporting to DCF as programs focus on their own investigations. We're really happy to work with the committee to address this, and I think it's all of our intent to make it work and to maximally protect children. It's necessary for child care programs to conduct some form of review and information gathering for their purposes and for their own administrative oversight, and to collect enough minimum facts to make a report to DCF. The appropriate way to do this is to make the report to DCF as soon as practicable, as required, and then communicate with the investigators at DCF, OEC, and police where that's applicable. That way, we're ensuring there's no interference with the formal investigation. These nuances could be part of what is incorporated into the protocol and checklist if that is what is envisioned for this proposal. But it'll be really important that the language in the statute is clear that this protocol would not absolve schools or child care programs from their responsibility as mandated reporters, nor empower these entities to conduct their own investigations into allegations of abuse or neglect in place of DCF. OEC and DCF work very closely together, and we've discussed this bill, and we're in alignment to work together with you on Section 10. Section 13 of this bill requires SDE and OEC to develop a checklist to be used by local and regional boards of education and child care centers, group child care homes, and family child care home providers to screen applicants and prospective employees during the hiring process. The current licensing regulations for child care programs do require that prospective employees undergo a check of the state's Child Abuse and Neglect Registry, fingerprint-based national and state criminal background check. And as currently drafted, and again, we're open to work with you, the intent and scope of this checklist is not clear, but just know that that regulation that I stated is in place. Thanks for your time to testify, and I'm really happy to answer any questions. And I'm so happy to see my friend Tammy Exum here, who has a seat I used to have. Tammy, good to see you.
Good to see you as well.
All right. Thank you so much, Commissioner.
Sure.
Representative Linehan, do you have a comment or question?
Yeah, I think we've gone through a lot of it. And so I just wanted to comment that I always appreciate when you come here. And so thank you for being here with our committee. And, I think what's probably going to happen is we'll rewrite some parts and then get back with you kind of thing. But
Exactly. I
well,
think
one
we
of-
all have the same goal and intent, and we all know there've been situations that have not been ideal when it comes to background checks. So we're all working hard on this. So we'll work with you, but happy to answer your question.
Yeah, you've really worked hard on this, and I want to thank you, of course, for all the work that you did for these background checks. Both you and Commissioner Durantis, it was like we all worked together so great because you understood the end goal and how important it was. And I think that's going to be the same on this legislation. We're going to get it to where it needs to be. I just want to throw one thing out.
Sure.
Sometimes everyone comes and testifies on what's in the bill, and we don't always hear about what should be in the bill. So at some point, if as you sit and think before we meet, if there's something that we're missing that could strengthen the ability to keep kids from being abused, that's what I care about.
Yeah.
So if there's something you could think of in the next week or two before we sit down,
Sure.
I would love to know that. Your expertise
Yeah, and
will
I'll
come
talk
in.
to my team. And we have a licensing team that's pretty incredible, that's out there every day, and we have an investigations team. So I'll ask Deb Johnson to reach out to them to see, is there anything missing here? Because this is an opportunity, a bill like this.
Great. Thank you so much. I appreciate you, Commissioner.
Mhm.
Thank you so much, Commissioner, and we will be bugging you, talking to you about some of the other bills that we need your insight and input, and your entire.
Yes, you
team
do
has
have
been
some
very
there.
helpful to begin with.
Yeah. Okay. Awesome.
Okay, thank you so
Thanks
much.
so
Thank
much.
you for
Have a
for
great
your
afternoon.
testimony.
Yeah. Bye-bye.
You too. Stay well. Our next person on our list is Lucy Nolan, and I think along with Lucy, we will have Lisa Gilberto, who will join us as well. What I can just do is, Ms. Nolan, Jean, you're going to tell us something?
Senator number 29, Beth Hamilton. She'll be speaking for Lucy. And number 27,
Okay.
Lisa, is also with her.
Okay, so Beth Hamilton is going to be speaking right now,
Yes, please.
along with Lucy. Okay, and should I give a little bit of a background of what's going on for everybody to be aware?
I think we could ask them.
Yeah, let's
Okay.
let Lucy Nolan explain.
Okay, good. Ms. Nolan, please go ahead.
I think it's actually going to be me. I'm not sure if you are hearing me
Okay.
rather than Lucy right now. Yeah, perfect. Okay.
Yeah, we
Lucy
can
was
hear you,
able-
Ms. Hamilton.
We were working to have a survivor anonymously come on with us, which is why there's a little bit of extra to do. Good afternoon, Senator Anwar, Representative Linehan, Senator Kelly, Representative Dauphinée, and members of the committee. Thank you for the opportunity to share our support of House Bills 5242 and 5243. My name is Beth Hamilton, and I am the Executive Director of the Connecticut Alliance to End Sexual Violence. The Alliance is the state's coalition of community-based sexual assault crisis services centers who provide 24-hour crisis intervention, including hotline services, counseling, support groups, accompaniments in hospital, police, and court settings, and advocacy while navigating complex processes. In addition, the Alliance's attorneys on our Victims' Rights Center of Connecticut team, which Lisa is one of, who you'll hear from shortly, provide no-cost legal counsel to victims, and our post-conviction victim services advocates provide victim notification services to victims whose offenders are being supervised by the Office of Adult Probation Sex Offender Supervision Unit and the Parole Special Management Unit. For nearly 40 years, the Alliance has provided comprehensive victim-centered and trauma-informed services to child, adolescent, and adult survivors of sexual violence across our state and partnered with communities to prevent sexual violence. As the pandemic created conditions that both increased sexual violence perpetration and survivors' isolation post-assault, we saw the number of children and families reaching out to us for services climb. With children being given unprecedented and often unsupervised access to online spaces during the last 2 years, there has also been an international increase in online exploitation, including here in Connecticut. Over the course of the last year alone, we've seen a nearly 12% increase in children under the age of 18 disclosing being victims of sexual violence, and those numbers are only increasing as our advocates continue to be welcomed back into schools and communities. All too often, the sexual violence experienced by children begins online. Grooming is frequently used in virtual spaces, enabling those seeking to cause harm to chip away at virtual boundaries before escalating to boundary crossing in person. Online grooming and mistreatment, as well as victim blaming that children experience and the lack of accountability for those perpetrating harmful behaviors, normalizes abuse, which enables it to escalate into adolescence and adulthood. With more children than ever having access to the internet and few opportunities for meaningful and ongoing education about online safety, it is critical to invest and establish sustainable responses to online abuse and exploitation. Our coalition can provide ample real-life experiences of the ways that online platforms are used to establish or enhance a harmful relationship with a child, engage in collecting and sharing abusive images of children, or seeking to parlay a virtual relationship into an online interaction. For these reasons, we respectfully request, to be included as a member of the task force so that we can bring the lived experiences of victims and survivors to the table. We thank the committee for your work in considering the impacts of online spaces and the safety of children, and extend the expertise of our coalition to support these efforts. We would also like to express our support of House Bill 5243 and the inclusion of additional questions about sexual violence victimization in future Connecticut health surveys. However, we believe it is important to not focus attention solely on sexual assault or misconduct perpetrated by an adult, as many youths experience sexual violence perpetrated by peers or near peers outside of the context of a dating relationship, which is how those questions are currently asked in the YRBS. In addition, we support a mechanism for youth who disclose being abused or at risk of being abused to receive immediate support, and the adults who are responsible for those interventions having ongoing training to ensure their ability to effectively intervene. We see House Bill 543 as a necessary next step to reinvest in helping our school communities to support children who have experienced sexual abuse and create school climates that support the prevention of sexual violence. There remains a significant amount of support, resources, and policies needed by schools to successfully come into compliance with the 2016 legislation requiring sexual abuse awareness and prevention programs in our K-12 schools. Please know that our coalition is a resource to the committee, and we look forward to any opportunity to support child sexual abuse prevention efforts in our state. I also want to introduce, and I am very thankful for, a secondary survivor, which is why we used Lucy originally to sign up. And we appreciate your help in bringing her here today. She wishes to testify anonymously about House Bill 5238. And we will also have her joined by one of our Alliance attorneys, Lisa Gilberto, who is working with their family. As you're going to hear, it's imperative that we work to support children and families who are struggling with the real life impacts of sexual violence and create real pathways for early interventions for children. Thank you.
Thank you so much. Ms. Nolan?
Hi, thank you. I was signed up to help our survivor to speak anonymously. And so she is speaking under Lisa Gilberto, who, as Beth explained, is from an attorney from the Victim Rights Center of Connecticut. And she will keep her screen blacked out as she speaks. But I do want to say, if any of you want to speak to her separately, she's more than happy to talk to people. She just, given the sensitivity of her case, she doesn't want this to be public. So I think, Lisa, you're up. Thank you.
Good afternoon, members of the committee. I'm attorney Lisa Gilberto. I am one of 4 attorneys with the Victim Rights Center, and I'm here with my client is 12 years old, and I am here with his mom, and she would like to speak. So given the nature of this, I'm going to black out my screen, and she will be the one speaking.
Hello, I'll just be known as Connecticut Mom. Thank you, Senator Anwar, Representative Linehan, Senator Kelly, and Senator Dauphinais for listening to this story. It's a hard one, but it is affecting a real Connecticut family. I'm a registered nurse by profession. I'm a parent and I'm a fierce advocate of an extremely brave little boy who told that he was being sexually assaulted. His perpetrator was a very close family relative. I would go as far as to say that a sacred role was violated. And that's as much as I would say. On December 21st, he disclosed that he was being sexually assaulted. And this journey has brought a bunch of systematic issues that I have had to endure as a parent. I used to be a teacher as well, then I became a nurse. So I have these lenses as a background. And one of the things that I do as a nurse is care coordination. So I'm always looking at these things. And I've just been shocked at how difficult it has been to get my 12-year-old son appropriate psychiatric care after being raped for 4 years. We've had issues that include inadequate DCF intervention. My son disclosed 4 years prior when he was 7 years old. My son has ADHD and he also has autism spectrum disorder and has communications issues. So at 7 years old, he was able to disclose as much as he was able to disclose. Like Representative Linehan said, and as a mandated reporter by profession, I said something, even though I wasn't sure, because it's as a parent, you don't want to believe this, and it's very hard to believe that this is real. Just your brain wants to shut down and just wants to say, this is not happening, this is not real, and that's it. So what ended up happening, I reported it to DCF, New Britain PD, and we went to Yale Forensics. It was unsubstantiated. The perpetrator ended up passing a lie detector test. The DCF social worker actually told me that I was lucky I wasn't thrown under the bus for reporting, for making what was kind of assumed to be a false claim. And that allowed my son to be sexually abused for another 4 years. 4 years later, in December 2021, he made a second disclosure. This time he was 11 years old. And this time he was able to give irrefutable details at the Yale Forensic Institute as to what the sexual abuse, the extent, where it was happening, very specific details in a childlike manner that no child should ever have to expose. And your worst nightmare, yes, this was happening to my child. And no, we had no idea. We had no idea it was happening. These perpetrators are trusted individuals. And you can do everything you can to protect your child. And as a matter of fact, because of the intervention of DCF and New Britain PD the first time around, not substantiated, it actually even put my guard down a little bit, because I was like, okay, well, he wouldn't do that. So I'm so thankful that my son was brave enough to say no more, and that I listened. And the school social worker who was trained, very well trained, and the New Britain Police Department the second time around, who also did an amazing job. DCF, on the other hand, they closed the case. I told them I was not comfortable with the psych plan that was provided now that he's, a survivor, now that he's disclosed. And they kind of just sort of forced me to accept the plan that they came up with, which I knew was not appropriate for my child who had special needs. So it's been hard. It's been very hard. So another thing is, I have private insurance. Private insurance is a barrier and an obstacle to care, to pediatric psychiatric care. I get about $1,000 taken out each month for medical benefits. Then I have a $6,000 high deductible. So I'm paying over $16,000 for medical insurance. However, I cannot easily access pediatric psych care because everything is Husky based. So I have experienced either delays in care or straight out denials in care. And there's been lapse in care. There's been no care coordination. because everything's Husky based. And once they hear private insurance, then it's like a mad dash to try to find a provider that will accept your insurance. So it's been really hard. So since my son disclosed, he's had 6 ER visits, 1 intensive outpatient program, lapse and transitional care, a partial hospitalization program, an attempted trauma-focused therapy, extended day treatment program, and he now has ABA therapy and multi-system family. All of this has been within 14 months. So anyone who is in healthcare knows that continuity of care and consistency is extremely important. I am now looking for a 5th psychiatrist to prescribe my son's medications because the psych providers are attached to whatever program my son is with. So he gets, the program finishes, they don't find appropriate transitional care, or they'll just say, oh, the next agency will take care of it. And here I am yet again, trying to find a new psychiatric prescriber, rehashing the whole story again. And then in addition, having services terminated early because of private insurance, or having Yale twice tell me that ICAPS is probably the most appropriate program because my son does have special needs, and being flat out denied. The Office of Voluntary Services through DCF has a company called Beacon Health Options that kind of tries to guide you through temporary Medicaid. And what I was told, even after that story of being sexually assaulted from the age of 7 to 11 by a close relative, I was told that he does not meet the threshold for temporary Husky, and that their job is to exhaust all options within my insurance before they would even consider issuing temporary Husky. It's not fair to make a family go through this. We are already living through the worst nightmare second to actually losing your child, and trying to find this child's appropriate treatment so that we could deal through this and get him to heal. And having to deal with insurance companies and authorizations, and having a million people calling you is a full-time job on top of the 40 hours I already work, and on top of the behavioral issues that I have because my child is traumatized. So moving on. What I've noticed from this whole experience also is just that when a sexual assault happens, everything's very offender-based. The crime is offender-based, the trial is offender-based. The victim is kind of an afterthought. DCF was very quick to just say, oh, no, you're a responsible parent, you handle it, okay? Even though I've had to go through, 5 different programs, 5 different psychiatrists, 6 ER visits. But my thing is, if the state of Connecticut can offer state-funded sex offender treatment, okay, for my child's rapist, okay, then why can I not have Husky for my child victim? That is all I'm asking for. That is all I'm asking for Connecticut families. We should not have to be burdened with, in addition to working, coordinating these therapies, deal with a separate full-time job with just to be able to access care. And then the thing is that it's not equal care when you have private insurance. I'm paying $16,000 for private insurance that does not allow me access that Husky does. So my child, who is the victim here, we are struggling to get him care, appropriate psychiatric care. It's been really, really hard.
Madam, to interrupt, if I may ask you to provide closing comments, and we'll open up the for questions from the committee.
I'm sorry. Oh, closing comments. Yes, sorry. So in my closing comments is this bill is a great start. I think it would help families with private insurance because really we're trying to help the child sexual assault, the child victims of sexual assault. And I just want to refocus our efforts and attention to the child victim and what can we do for the child victim. This is about the kids, and we as a state have to do better for the kids.
Thank you so much, Connecticut Mom, and thank you for your courage and thank you for sharing your pain with all of us so that we can at least make sure that we create protections for others. And I wanted to thank Beth Hamilton as well as Lucy Nolan for your work and Representative Linehan for your work. And Representative Linehan, please go ahead.
Thank you very much, Mr. Chair. Connecticut Mom, thank you for being here. Your story, I mean, I felt it. I didn't just hear it, I felt it. And I knew a bit about your story, which is why ultimately this bill came to be. And first of all, you do have a very, very brave little boy. And I'm really proud of him. I think that your story actually highlights way more than the one bill you're here to testify on. We are in the midst of putting together some of the most comprehensive mental health legislation for children that the state has ever seen. And in your testimony, you've highlighted a lot of the holes that we're trying to fill with that bill, in addition to highlighting a lot of the problems that we're trying to fill with our adult sexual misconduct bill, in addition to trying to solve the problem that your family now has with getting your son treatment. So I want you to know, sometimes, you know, I think to myself, okay, like, so why have I been put on this earth? And it's stories like this that remind me that I'm put in the position I'm in to make changes because of you and your family. And although we can never take away your pain or your child's pain, we work very hard here to help solve the problems to make your pain livable. So sometimes it's easier knowing that there is a reason why you are forced to stand up and talk. And I want you to know that your time here today is working to help thousands and thousands of children in the state of Connecticut and all families in the state of Connecticut. With that said, I don't want to ask you too many questions in the public sphere. I welcome the opportunity to meet with you privately, but I also want you to know, and I know that Lucy knows how to get a hold of me. I would like you and Lucy to contact me because we're going to find your child some help immediately. We're going to get him what he needs.
Thank you.
So with that, I'll go back to you, Mr. Chair. Thank you very much.
Thank you, Madam Chair. Representative Wielander.
Thank you, Mr. Chair. I just wanted to echo the thoughts of the chair of my committee. From one mom to another, thank you for taking the time to speak with us today. I also want to commend you and your son and your entire family for the bravery and the resilience that you are showing in your everyday actions. And so just thank you for that. And I will do whatever I can to assist Representative Linehan in getting you the care that you need. And just to reiterate that the actions that you are taking right now, I was not aware of your story beforehand, but the actions that you are taking right now are going to make sure that anyone who has this happen to them, maybe it'll help prevent some of that, and it'll help prevent some of the further trauma of not being able to get the care that you all needed. And so I'm sorry that you haven't been able to get that care. And I thank you again for your time. And Beth, I will be reaching out to you about the task force. And I think, and more information offline to make sure that we can get as many of the important perspectives, especially those who have lived through this trauma, as part of the process in addressing it. So thank you very much for your time, Mr. Chair.
Thank you so much. Thank you again, Connecticut Mom, for your testimony and your hard work, and Connecticut Son, we love you. We are so sorry, but we are with you. We stand with you. Thank you. And thank you, Ms. Nolan, and thank you, Ms. Hamilton. And with that, we will move on to our next speaker. That's Representative O'Day. Thank you, Representative O'Day, and for your time. And sorry we took us a little while, but we're so glad you're here. Thank you.
No, please. Chairs Linehan and Anwar and ranking members Daphne and Kelly, members of the Children's Committee. That's a hard testimony to follow up with. But on behalf of the Republican caucus, thank you for raising SB 208, and that concerning social media and parental consent. And I think as tough as that prior testimony was, it's not a horrible segue into this issue, which is protecting our children. Our caucus requested this bill to protect children from the potential dangers of joining social media platforms when they're ill-prepared to handle such dangers. And I submitted written testimony, which I won't read here any further, but in essence, the Federal Children's Online Privacy Act, COPA, became law in 1998. And since then, things have changed dramatically, as we've all seen. And so this bill, in essence, raises the age of requiring parental consent from 13 to 16. And so the target of this is not the providers, for example, whether it's T-Mobile or Verizon or AT&T. It's the social media platforms, the Facebook, the Instagram, Snapchat, which I frankly just signed up for. I don't even think I did it right. So I see these things come up and I have no idea what's going on. So I shouldn't even be on it, frankly, but my kids are, and I'm trying to figure it out. So in any event, I will cite one part of my testimony. There was a Wall Street Journal article entitled "Facebook Knows Instagram is Toxic for Teen Girls," company documents show. And shockingly, 32% of girls who previously felt bad about their body felt worse after using Instagram. That's outrageous. I will also pass on, a friend of mine was a consultant in a company, the head of Alex Partners, and he was at a presentation and ended up talking to some high executives high up at the major social media platforms. They don't let their kids have access to older than this, and they monitor it themselves. These are the people that put it together, and they know how bad it is for their children. So happy to answer any questions. One other thing I would like to mention, if I could, just briefly, HB 5240 was mentioned. The boy who died was in my son's grade, and he's from New Canaan. It involves the neck guard on hockey players. So he's from New Canaan. He went to St. Luke's, and the family does not want their name tied to the bill not because they don't want it done, but because they don't want anybody to feel guilty. It's a wonderful family, and so I appreciate you bringing that up. That HB 5240. I would also ask, if possible, I had submitted a request to look at EKGs for athletes. A gentleman by the name of George Duraco is a friend of mine. His son Art Duraco, his son, George, was a student at Wilton High School. He passed away, and George likely would have been saved if he was given an EKG before participating in any athletics. Shockingly, there are many, many children who die. It's one of the highest causes of death, sudden cardiac arrest. And upwards of 90% would be found if EKGs were required. Now, I know there's a concern about that, but at least maybe a study, if that could be put into this study. I'm not sure if it should be on its own. But if you could look at sudden cardiac arrest as a possible requirement of EKGs for student athletes, again, I'm not a mandate person by nature, but if this can save a life, and Artie Duraco has offered to, he gets them done for free from providers if they're not covered by insurance. So anyway, I'm sorry to digress from SB 208 into 5240. Happy to answer any questions. I really do appreciate I know, sorry for the emotional roller coaster today, but I appreciate all your service. This is a tough committee to serve on. I've never served on it, but thank you.
Thank you so much, Representative O'Day, and then we would welcome you to join this committee as well. This is a committee that, as Representative Leonard puts it, as a small committee that can, because this committee does take a lot of important critical issues, and we make it happen, and we make it happen in a bipartisan fashion, because we throw every politic, every issue out of the window when it comes to our children and the state's children. And your testimony is also a testimony to that, because the bill that you have, actually, I had a bill same as yours, and I felt that because you had put the bill and we put your bill forward, and I've actually co-sponsored it as well at the same time, because of the value and the impact that it has on our children. And as we look at the mental health challenges that our children are enduring right now, social media is part of that issue as well. And then your point about the EKG for the prolonged QT interval issue, and also hypercardiomyopathy that is seen in subsegment of the children, where if God forbid they are very active in a situation with that cardiomyopathy, sudden cardiac death happens, that would be part of that, along with looking at some of the other injuries with specific sports. So that's going to be a very important committee, which is going to look at a comprehensive strategy. But your words are of great value, and I have two of my colleagues who want to ask questions. First one is my co-chair, Representative Linehan.
Thank you, Mr. Chair.
Thank you, Mr. Chairman. Hi, Representative. How are you today? I'm glad you're here. I guess, the senator really covered it, that those are the kind of things that I think everyone will be looking at with the study. I think that that's really important for see if baselines are important. And so I welcome you helping out with language and working with us on this. But to talk about the internet bill, I guess my concern is this, like, first of all, I wanted to raise it immediately, but had you said that we would make it illegal for all teenagers to use social media, I probably would have raised that too. You're right, it's horrible. And I can't believe you're on Snapchat. That is the worst of them all. I hate Snapchat with every fiber of my being. But my concern is kind of where do you want to go with this bill? So right now, the bill seems very simple, that we just have parental consent for being on social media. But my question to you is how, right? Are you going to, do you want to require something like, I imagine it like two-factor authentication? Because I know my kid, if I can't get into something, she's like, I'll hack into that for you. And she's turning 13. So, is there an idea on how to make it more than just checking a box, I guess?
Great question. Thank you for that. I don't have an answer for that. Frankly, I signed up for the first time with, well, first of all, to the Snapchat question, this yellow thing pops up. I have yet to be able to use it. So I'll probably just delete it from my phone. But I signed up for DraftKings, to just what's all the hoopla about. I'm not much of a gambler, so I just tried it out, and I have a hard time with that in and of itself. So my long-winded answer to you is, right now the law applies to under 13. So my only comment would be, however they do it, I don't have anybody in my household anymore that's under 13. So I don't know how they do it now for those under 13. So I guess my easy answer is, however they do it now for those under 13, I would do it for those under 16. So
yeah, so let me tell you though, because you're going to need to know this. Because I do have, all of my children are under 13 at this point. My daughter turns 13 next month. There is just simply a box that you check to declare that you are of age. It's the same way like you go to a beer website or a liquor website and says, are you 21? You click yes. There's no way to prove it. So when I was thinking about this, I thought, well, it would be really nice if when my kids signed up for Snapchat, they had to, somehow require that there was a two-factor authentication for the parent to agree to it. But who says they're not going to put an email, their friend's email, or they're still going to just say, I'm of age. So I get what you're saying, and I agree with it. I'm not arguing with Bill. I just think that we have to put our heads together and figure out if there's something we can do, because, a lot of this is federal, right? And so when we make a law that is stronger than the federal law, the ability to circumvent that still works for everyone else, right? And ultimately, if we were really going to make things better in this space, what we would really need to do is require Apple and their iOS system to allow for parents to have access to everything their kids are doing on their phones, but they don't. So there's so much federal things that need to be done. I am all for putting this together. I think that, and I'm just talking off the top of my head though, in addition to the changes that you're looking for that agreement, we need to do more. And I think there needs to be direct marketing to parents about the dangers of social media to their kids. And I think that we should provide funding to do that. I think that's important. Would you be amenable to that?
Absolutely. I just don't want the funding aspect to kill the bill. I would say we could raise the age from 13 to 16 under the current law, and the checking the box is obviously not enough, but I wouldn't want to tie funding to this to then kill, which would then kill the bill. But to your point, I totally agree with you 100%. We've got to do more. And aren't we buying, is there, I should know the answer to this. I think we can buy liquor online. So there's some form of authentication on buying booze online, liquor. So I got to believe there's a way to do it, whether it's through the two-party authorization or uploading your driver's license, or I don't know the answer, but
buying liquor online and buying cigarettes and tobacco products online requires an upload of your license. This committee tried to pass legislation that also would require that your ID exactly matches the credit card using to purchase something, but that there's no purchase on social media. And kids don't, but 16, you don't necessarily have an ID. I get where you're going and I like it, but I do want to just say regarding the killing of the bill, just think of it this way. And I think when we talk about funding, it doesn't have to be that much, but I had a constituent who was was offered 10,000 TikTok followers if they simply downloaded this one app. She was 12, I think at that. I'm looking at my husband. I think she was 12 at the time. And she downloaded the app. It brought her into a chat room where she was coerced into providing sexually explicit videos of herself to the people in the chat room, or else they would come and find her parents and kill them. So it's so much bigger than just and I'm not saying just like I'm minimizing it, but so much bigger than the self-esteem aspect. I think that's a big important part of it too. But we're also talking about like real danger, where I can make the argument that this is really, really affecting our children down the line and with their mental health, and that any investment we put forward to alert parents to what this is and what happens to our kids is actually saving us money down the line. Because, you know, it always costs less to stop something from happening than curing the ills that it caused. So just be open to it. We'll talk more offline, but I just think that is something important to think about. Thank you very much, Mr. Chair.
Thank you so much, Madam Chair. I just wanted to make a quick little comment when we go to Representative Lanu. I think Senator Blumenthal said that this is a big tobacco moment for the big tech companies, where they have been actually growing rapidly and have been irresponsible, impacting our children. And I think this is one step in the right direction. We didn't get here overnight, and we won't be able to solve it overnight, but we have to start that journey. And I think Representative O'Day, your point about starting that journey is a very strong one. And then we can start to work together and continue this journey going forward together. Representative Lanu.
Thank you, Mr. Chairman. Representative O'Day, how are you, sir? I want to thank you for coming before us today. This is a crucially important issue, and one that's long overdue. And I want to just thank you for putting this in the forefront. You know, you mentioned COPA in 1998. You know, and you just think of how the technology has grown up since then. You talk about young girls going on social media and they having worse body image issues and issues with bullying. You know, 1998, I was in high school. I was a sophomore. I'm aging myself here, but and I remember, you know, there was bullying. There was a lot of kids had body image issues. They would, and I'm not downplaying that at all. It's horrible during any period of time, any segment of time. But there was a period where you left school, and there was no, in 1998, there was no social media, there was no Facebook, there's no Snapchats. You go home and you had the parental perspective. You had your parents, and you got to talk to them and spend time with them. Now with the technology we have, unfortunately, one of the downsides to that is a lot of that bullying, a lot of those body image issues becomes 24/7, becomes a 24/7 problem. And I can imagine 13, 14, certainly you're not fully mentally mature, and you need to have your parents need to know what's going on, and they need to know what you're getting yourself into. And I agree. Any additional mechanism to try to get that verification from parents, if there isn't somebody under the age of 16 that's trying to skirt that verification, maybe gets a friend involved, or I heard that example. The more hoops you have to go through. Would you agree with me, Representative O'Day, that the more hoops a child would have to go through, there's a good chance they're going to get caught. Their parents are going to catch them. So if they're using another child to help them, maybe their parents would catch it, and there's going to be there's a greater chance of exposure and finding out that your child's going on social media. Would you agree with that?
Absolutely, Representative, and I think, and I really want to thank your comments and the Chairman, Senator Anwar, and Representative Lenahan, Chairman Lenahan. I mean, this is a bipartisan issue of protecting our kids. I don't have the answers as to how to best do it, but as the good chairs stated, this is a first step, and I agree with you completely, Representative.
Yeah, and I certainly you have to verify alcohol purchases and cigarette purchases. Certainly, to get on social media, make sure parents know what their kids are getting themselves into. We need to have that verification process. So, I very much look forward to seeing how this legislation materializes and this issue materializes. And again, I want to thank you for standing up publicly and advocating for this. And I look forward to supporting a good, meaningful legislation that moves in that direction. Thank you very much.
Oh, thank you. And just to be clear, this is a caucus position, so I wasn't the sole one. And I know, Senator Anwar, I know this is one of your main ideas for the session. So thank you for allowing us to bring it forward and giving it a hearing and for your support.
Of course, thank you so much. And I wrote an op-ed about a few months ago, and then I'm just following along with the same path as well. You're absolutely right. And Representative O'Day, before you leave, I just sent you a friend request on Snapchat.
I have no idea how to do it, but I'll try. Thank you.
Neither do I. So with that, I have the next speaker is my friend, Senator Craig Minor. Senator Minor, thank you for your waiting, and we look forward to hearing from you.
Thank you, Senator Anwar, Representative Linehan, Senator Kelly, and Representative Dauphiné, and committee members. I'll admit this is probably the longest that I've spent watching the Children's Committee in a public hearing, and I hope the public has some idea of how difficult this process is and how thoughtful the questions are as you introduce legislation and then try to find your way through what's been drafted in the hopes of actually solving something. I'm here today on behalf of the Senate Republican Caucus testifying on House Bill 5244, which in many ways is similar to our Senate proposal, which ended up in the Judiciary Committee because it was a more broad spectrum piece of legislation that included a lot of issues, only some of which would be generally before the Children's Committee. The subject matter is not only opioid abuse, but also the presence of fentanyl in our society. Statistically, I think it's been proven that in 2021, 1,374 people died of opioid overdoses, and about 84% of those were fentanyl involved overdoses. Back in January of this year, I think we were all shocked to find that in any school in the state of Connecticut, there were some 40 bags of fentanyl located in a school locker. And so I think for all of us, that's what kind of raised my awareness, our caucus's awareness, and certainly the Children's Committee's awareness to how deadly this issue is, how instantaneously that substance kills when only a couple of grains of the product need to be present. I've read the bill that is currently before the committee, and I'm happy to support the bill. I would ask for a couple of changes in the legislation, and I'll tell you why. Early on in the language, the first section, it seems to indicate that the first available dollar would be in fiscal year ending 2023. So to put that in layman's terms, there would be no ability under the legislation if passed to assist municipalities with having these products available in any school in the state of Connecticut because the law wouldn't allow it until July 1st of 2022 at the earliest. And then we would be kind of waiting for someone else to make a decision when that money would be released. I indicated that the circumstances are already in front of us. I mean, I couldn't tell you as I sit here today that there isn't a bag of it somewhere in the Litchfield school system. And it frightens me to say that. Frightens me. I have grandchildren that are in the public school system in many towns in the state of Connecticut. And so that's the urgency, I think, that I want to bring to this issue. As you continue to look at the draft legislation, I think there are other ways that it could be crafted in an effort to make available funds that clearly are in the governor's budget. Some of them are actually moved forward from FY 2021, if you can imagine. Some, I think it's $138 million still remains. So we could clearly put some money on the table sooner rather than later. I would also ask you to look at line 248, line 242, where it says these products may be in a school system, meaning, at least to my mind, that we're leaving the door open that a public school system in the state of Connecticut may choose not to. I couldn't imagine how we could pass legislation and, if we're going to pay for it, provide an opportunity for a town not to make this available. The language is pretty clear. It requires education. It requires that it be done under the guidance of a medical professional or a school nurse. It provides language for someone else to be trained. But in line 242, a school nurse, in the absence of a school nurse, a qualified school employee may maintain opioid antagonists. So I think, to the extent that that could make clearer that the Connecticut legislature is not in a position to make that an option, especially when we go on further to say that no school can be actually open during normal school hours without having someone trained, either a nurse or someone that would be qualified under some training provision established by the State Board of Education. So those are just 2 points that I would raise in the hopes of moving the bill along. And because it is a House bill, obviously, to try and make a recommendation for an amendment in the Senate becomes problematic. I certainly would like to get this bill passed as soon as possible for all the reasons I've already discussed. And if there's another area that might kind of provide opportunity in the future, at the very end of the bill, there's some language in there that talks about the group of individuals we think should be able to provide this life-saving medication, provided there's not a direction given by a parent not to issue it. And I don't know if there's a broader list that might be considered at some point in the future. From my perspective as a parent and a grandparent, if the Litchfield school system, based on what I know about these products that I believe are not unhealthy if administered to someone that isn't actually suffering from an overdose, right? So from my perspective, if the school system chose to make sure a whole bunch of people, including a custodian that was in the right place at the right time and might provide an opportunity during some late band rehearsal or whatever, could actually issue it, I certainly wouldn't want there to be a bar in that group because there's just, time is of the essence. And when I think about school systems that may have a school in a grammar school, a nurse in a grammar school, not in an intermediate school, I think we should do the best we can with what we have, but in the future, there may be an opportunity to expand that list in the future. So thank you for providing me this opportunity to testify on behalf of Senate Republicans, and thank you for including many of the ideas that we had in our proposal.
Thank you so much, Senator Minor, for your testimony. And I think when literally every caucus has the same idea, that the time for that idea has come. And I can clearly tell you that this bill is part of what literally every caucus and multiple legislators have put forward. Senate Bill 2 has this concept in there as well, in the way that you're describing, and you have envisioned as well. So which again shows that we are all thinking in the same direction. And you're absolutely right. The downside is not there. And with the nasal Narcan that is available, anyone, you don't have to be trained. You can actually look at an app and learn how to do it in about less than a minute. And so we need to make sure that it's available and people know how to use it, and make sure it's accessible. And there's no downside to it, like you just stated. It's only upside, if you will, in that situation. So thank you for your testimony, and I will have my co-chair ask you a question, I think, in a comment. Thank you, Madam Chair. Go ahead.
Thank you, Mr. Co-Chair. Senator Minor, thank you for being here today. And I echo what my co-chair said. When all the caucuses are putting forth similar legislation, he's right, the time has come. But you did have a question in there that I wanted to be able to answer for you, and see if, knowing the answer, you still support it. So you had asked why we are making it a may versus a shall, why we're not mandating this. And the reason being is that this legislation, which is different, a little bit different than what everyone else has put forward, is because it requires, if a district avails themselves of the ability to have the opioid antagonist in their school and have the state pay for it, that they are also required to take the adolescent expert training, which is substance abuse, brief intervention, and referral to treatment. And I've done this before in my district. Essentially what it is it's for a lay person of any kind to recognize if someone is using drugs. And it also allows them the confidence and ability to know what to do if a child comes to them and says that they are doing drugs and that they need help. And then they can refer them to treatment. What we find is that many times a teacher will say, well, let's take you to the nurse. You could go talk to the guidance counselor or something. What we're trying to do is to keep that relationship intact, because there's obviously a level of trust if a child is talking to a parent or a coach or a teacher about substance abuse. So this legislation requires a train the trainer model so that and I forget, I don't have the legislation in front of me. We have someone do it. I believe it's DCF who also utilizes the expert training. They go into the school system and train some people in the school system, and then they become trainers themselves and can train their staff. So the mandate part would say that everybody has to now do this training. They need to have people kind of doing the trainer model. They have to say who's going to do that in their school in order to get this funding and the naloxone. The problem is if we mandate that, we're definitely going to get a pushback. Some places aren't going to want to do that. They're not going to want to do the training. But it's also really important to tie them together, because saving a life is hugely important. But what we say in this committee all the time is if we have the ability to save a child from getting to that crisis point, then that's what we need to do as well. And that's where the Adolescent Expert Program comes in. So knowing that those two things are connected, would you still like to, I mean, we can make it so I don't believe that I didn't read the language to say that a district cannot have an opioid antagonist in their school until such time. It's that we will pay for it at that time. There's nothing keeping a district, to the best of my knowledge right now, from having that in their school anyways. So knowing what I said about how the two things are connected, would you still support it being a mandate for all schools?
So first of all, I do support a mandate of providing training within the school system for the dispensary of these opioid antagonists. I don't personally have an issue with the other concept, which would be more of a concept that talks about awareness and how to recognize addiction and drug use. My children are now old enough to have children of their own, and I've seen this for the better part of 40 years. And so there's no doubt in my mind that this is probably getting worse, not better. And back when my kids were in high school, it was marijuana and not legal gummy bears. I'm not sure that every child in the school system even knows they're taking drugs. And I guess that would be the distinction. As far as I'm concerned, fentanyl only needs to be a couple of grains. I don't think the committee wants to be perceived as tying the issuance of money from the state of Connecticut to help save lives in public schools to an acceptance of additional training. But I think the point is well taken that the additional training is important in today's society. So, I'll certainly watch to see how this bill progresses. We were trying to point out that we believe that there are some items in this bill that are consistent with our view. I really do think that the funding mechanism in the front part of the bill shouldn't be there. There shouldn't be a question as to whether or not the state's ready to put some money on the table. I would like to have thought that the administration would have made money available to any school system that already could demonstrate that they have a system in place. I'm not convinced that that's not the case, but I guess it could be the case. So for that reason, I would certainly look closer at the language that you're pointing out to me, but I still don't think it should be a voluntary situation.
Great,
I would
thank you
hate
very
to-
much.
I
Oh,
would
sorry.
hate to have a parent thinking that every school system in the state of Connecticut has something on the shelf and people trained to save a life, especially when it costs as little as $20 a dose.
Great,
So that-
thank you very
so
much.
that's my
so much.
reluctance. That's my reluctance in tying the two together officially.
Thank you, Senator Minor. Thank you for your testimony, and appreciate your testimony and your very thoughtful comments. With that, we will move on to next speaker, which is Sarah Egan, followed by Mark Baytel. Ms. Egan, thank you so much for your patience, and we're looking forward to hearing your testimony. Thank you. You're muted.
Thank you. The catchphrase of 2022. Good afternoon, Senator Anwar, Representative Linehan, Representative Dauphiné, all distinguished members of the Committee on Children. This testimony is being submitted on behalf of the Office of the Child Advocate. The obligations of the OCA are to review, investigate, and make recommendations regarding how publicly funded state and local systems meet the needs of vulnerable children. I provided written testimony on behalf of almost all the bills up for today. But a couple of things I wanted to highlight about a few of the bills. So I want to start with House Bill 5241, an act providing funding to school districts for the use of therapeutic day schools for special education. And I wanted to clarify, one, that the OCA strongly supports more funding for equitable education, more funding for special education services, more support for teachers and school districts to meet the needs of children with disabilities. But I did want to highlight that Connecticut is right now a national leader in the plate, and not in a great way, in the placement of children with disabilities in what are called by the federal government separate schools. We lead all states in this category for the percentage of children with special education needs who are educated in separate and segregated programs. Connecticut also ranks second among all states for the percentage of children identified as having emotional disturbance who are educated in separate settings, with almost a third of these students educated in separate schools. So I think that we are continuing to struggle in the state of Connecticut with supporting school districts to be able to program for children with a range of disabilities in the least restrictive environment. And looking at how we fund special education is very important. While certain private programs can and surely do a wonderful job for students, and OCA supports individualized determinations for each child, we feel that Connecticut continues to be painfully over-reliant on the exclusion of certain children with disabilities from public schools, and that this must be meaningfully addressed. I can comment more on that if people have any questions. I wanted to spend some time talking about Raise Bill 5243, an act concerning adult sexual misconduct, which the OCA strongly supports this package. There's a lot in here. It's an omnibus adult sexual abuse prevention bill, and it's great to see that again. You know that we strongly support multiple provisions in here. The youth risk behavior survey piece, which people didn't comment on yet today, do think is really important. That's a standard survey from the CDC, creates lots of great important baseline data for the state about kids' experiences. We do not have any baseline data in our state about kids' experiences with sexual harassment or sexual abuse. And folks should know that the federal research tells us that this problem is much more prevalent than people think it is. and that 9.6% of students have reported out being the victim of sexual abuse by school personnel, such as teachers, coaches, and bus drivers, sometime during their school career. So I think addressing this in a really comprehensive way is important. A couple of quick recommendations. One thing I wanted to point out to the committee, if you're not aware, is the U.S. Department of Education published a technical assistance guide for states and local school districts on this topic, adult sexual misconduct prevention in schools, with lots of terrific recommendations around training and toolkits. We'd love to see the state resurrect its sexual abuse prevention working group that it used to implement some state laws a few years ago to tackle how to implement this toolkit at the state level. So that's one recommendation we would make. The USDE strongly recommended that training regarding adult sexual misconduct be mandatory for all school personnel who have direct contact with students. I think this bill certainly moves strongly in that direction. One thing we would add is that it's critical that training regarding adult sexual misconduct, including bystander training, specifically address the unique risks and vulnerabilities for children with disabilities. Children with disabilities, and it may not be intuitive to all, but are a unique risk for abuse and neglect, and in particular, sexual abuse. Federal crime statistics tell us that persons with intellectual disabilities are victims of sexual abuse crimes at a rate 7 times that of the general population. And it is imperative that as we increase the knowledge and skill of child-serving organizations around sexual abuse prevention, that specific and targeted attention be paid to these risks. I'd also add, we recommend that the provisions in the bill regarding training and the coordinated checklist investigations piece might be amended to require either a working group to develop protocols or at a minimum consultation in that provision with state experts regarding child sexual abuse prevention and response, such as, and this is just one example, the Connecticut Children's Alliance. I think it's a good idea.
You wouldn't mind summarizing?
Yes, I will summarize. The last thing I wanted to mention, it's not in the bill, but because you have this omnibus bill, and I have other recommendations in the body of our testimony, is so we're thinking about the role of state agencies in investigating and documenting abuse, neglect findings. I wanted to point out that there's very little of the findings that become public and shared with parents and consumers. And I included information in our testimony about that. And I just want to, I don't want to go too over my time. So I know I was at the summarize part.
Actually, Ms. Egan, I was going to ask you that question about that particular thing. So maybe should I just ask you that question if you can help me with that. Thank you.
Yes, thank you. So what I mean by that is that when DCF comes into a child serving program and makes a finding that, and a number of findings that a child was, let's say, abused. Let's say that a program lead in a child serving program abused children in the program, right? Or emotionally abused or neglected a child or one or more children in the program. You know, that information largely remains confidential. There's notification to the victim's family, right? But there would not be notification to the consumers of that program or to other parents of children in that program. And I think Senator Anwar, you asked about that earlier. Additionally, DCF may make corresponding, what do they call, program concerns. And they may make those program concerns regardless of whether they substantiate or don't substantiate an alleged perpetrator. But they may say, geez, you know, we came here the 3rd time we've investigated this program. We're concerned about the lack of training, supervision, et cetera, right? And these are our program concerns. You know, what I'm raising in our testimony is what happens with that, right? That information is not going to go to the parents of the alleged victims. It goes in the body of the investigative document to the State Department of Education, and it goes to the superintendent, right? But to what end, right? It's not disclosed to consumers. I like that DCF does that. I think that's good, but there's no framework for transparency and accountability around those types of findings. We've raised these issues before with the legislature, and given that you had this bill today, I wanted to provide you that information and some recommendations about how to change that. And I'm happy to talk to you about more examples of how that occurs and why that's important. But I think we really need to look at the feedback loop when the department makes really important findings about a child serving program and its treatment of and how children are treated in the program. I went through that quickly. I hope that all made sense, but happy to answer any questions about that.
This is helpful. Thank you so much for your testimony. I think there is a question from Representative Linehan.
Thank you very much, Mr. Chair. I guess really my question is, if you, like, we need to get together and talk this out fully. Because I'm sitting here going, well, we passed that law. We passed that out of kids. And I'm looking and I see that it was never called in the Senate. And that's my bad for not recognizing that. So the bill that we had in 2018, 5334, would have required that the superintendent is notified, and that notification then is given out to the community. And that's there's no identifying information, but those who are in the sphere of the school employee who came in direct contact with children would be notified. So the fact that that wasn't called in the Senate, I apologize that I had been remembering wrong or something. But now I think what we really need to look at is that we need to maybe take a lot of that language and put it in this bill. And we're going to have to work closely to do that. So I appreciate you. And I know Representative Green was with us at that time. And she was very helpful with this legislation and getting it to where we could have a lot of people co-sponsor and be happy with it. So we'll have to work more on that. I'm sorry, I'm thinking as I'm live on TV here, that's probably not good. So we'll work more on that, Sarah. So thank you. I will absolutely be in touch quickly.
Great, thank you. Happy to help in any way.
Thank you so much, Ms. Egan, for your thoughtful testimony and all the work that you do and your guidance throughout the process, and truly your depth of knowledge on all of these issues. So it's just a blessing for the legislators, but also for our children in our state. Thank you. And moving forward, we have Dr. Mark Dell, followed by Andrew Feinstein. I hope I did not mispronounce your name, Dr. Betal.
Absolutely perfect. Well done. Thank you. Thank you, Senator Anwar, Representative Linehan, and all of the esteemed members of the Children's Committee. I would like to voice my strong support for House Bill 5241, an act providing funding to school districts for the use of therapeutic day schools for special education. By way of introduction, I'm a licensed clinical psychologist here in Connecticut, a research scientist in the Yale Child Study Center, an assistant clinical professor in psychiatry, and a lecturer in ethnicity, race, and migration at Yale University. I am also a chief administrator of a Connecticut state-approved private special education program that's known as an APSAP. Please note that I'm not speaking on behalf of any particular organization today. HB 5241 is vitally important for special education students in our state. Disabilities affect Republicans and Democrats, so this is something that could absolutely receive bipartisan support. Connecticut relies upon a well-established network of special education outplacement programs. These are the APSEPs that deliver kindergarten through 12th grade education in alternative settings to students with special needs. These programs are approved by the Department of Education, which promotes their use throughout the state. The approval process is rigorous. It involves a year-long self-study and a site visit every several years. School districts in Connecticut, as you know, have a duty to identify students in need of special education, to classify them by disability, and provide an individualized education plan, that's an IEP. While the vast majority of students are easily retained in the district, some require outplacement through a planning and placement team meeting, that's a PPT. This involves school district personnel, parents, providers, and sometimes even the students themselves. The school that I direct serves severely anxious and depressed students in grades 6 through 12 who require an alternative setting and specialized instruction. These are students who have multiple disabilities, who may present as suicidal. These programs save lives every day. Funding has been a major impediment to providing appropriate outplacement services. Far too often, students who need it are denied appropriate outplacements at the district level. This proposal would alleviate pressure on those districts, would ensure that funds are distributed to districts and students equitably, and would ensure adequate funding so that all students who require it may receive it. A minor technical point, going forward, I would propose that the committee adopt language that refers specifically to the system in Connecticut, which is Connecticut state-approved private special education programs, or APSEPs, rather than to the more generic construct therapeutic day schools, which has no legal meaning in Connecticut. Thank you very much for the opportunity to testify. I'd be happy to answer any questions you might have.
Thank you so much for your testimony, and thank you for waiting for a long time. I'm so sorry it took us a little longer. We got into too many in-depth and complex issues. I see anyone has any comments or questions. Seeing none, thank you so much, Dr. Bettel. Thank you so much for your testimony. We appreciate your insight. And we will reach out to you for clarification of some of the language specifics. Thank you.
Wonderful, happy to help.
And next person on the list is Mr. Andrew Feinstein, followed by Yaz Leo.
Thank you, Senator Anwar, members of the committee. I'm Andy Feinstein. You all remember me because I was number 174 in the testimony on House Bill 5001, which you all watched for 16 hours. I was midway point. I'm the legislative chair of Special Education Equity for Kids in Connecticut, SEEK, a statewide organization of parents, providers, attorneys, and advocates working for excellent education for students with disabilities. And I really hate to disagree with my good friend Mark Bytel on this, but we have real concerns about 5241. There are 80,000 kids in Connecticut with IEPs, kids with disabilities. About 5% are outplaced. And not all of those placements could, under any meaning of the word, be considered therapeutic. Some are, some are not. Now, we understand that public schools are often reluctant to outplace students with mental health needs. We agree that there are children who desperately need such a placement, and school reluctance can be a problem. But we think that whatever special ed money could be dug up for that grant should be devoted first to providing a multi-tiered system of support in schools, a continuum of therapeutic interventions, which in fact will reduce the number of kids that need to be outplaced. I provided some fairly detailed descriptions of the MTSS in my testimony on 5001, and I'm not going to go through it again. Now, we do have a system for very high price placements called the excess cost grant. We're not fully funding it, and schools are only getting now 67% of the amount they spend on a high price placement that costs more than 4.5 times the per pupil. I can talk a lot about that, but I'll just leave it at that without going into great details. I've spoken to Chairwoman Linehan about this and would be glad to continue the conversation, but it seems to me that the best thing we could do is to provide the teachers, special ed teachers we need, an incredible shortage area now, the therapists, the counselors we need in schools now to serve not only the 80,000 special ed kids in schools, but also to serve all the other kids. And maybe if we provide the continuum of services that they need, we're going to have fewer kids who are going to need to go to places like Mark Beitel School. That's what I have to say. I thank you very much, and I am glad to answer questions, of course, and I'm glad to work with the committee on trying to perfect, try to meet the goal that this legislation has in a way that I think is constructive for the entire system.
Thank you so much, Mr. Feinstein. Thank you for waiting for the testimony. I have a question or a comment from my chair, Representative Linehan.
Thank you, Mr. Chairman. And I promise after this, I'll shut up because I feel like I've been asking so many questions of so many people. But Andrew, thank you for being here. We have spoken offline, and I think that this is just for the benefit of the people watching and for the committee. Ultimately, what we're trying to get at here is taking the kids who are not doing well in traditional school because of mental health problems, not behavior problems. We're talking those who aren't safe in school, those who maybe, are self-harming in school, that there may be something even worse happening possibly in school, that those kids have an environment that is better for them. And we are told often that there are parents who believe that their children should go to these schools, and then districts don't do that. And the belief is that they're too expensive. We're trying to get to that, whether it's through this bill or something else. I absolutely love that Andrew Feinstein talks about wanting to have multi-tiered systems of support in our schools, especially for kids with mental illness, specifically depression and anxiety, or bipolar or something of that nature. I totally agree with you. And I just think that we can't always look at only one lane. We have to think about multiple lanes and how we get to the destination we're both trying to get to. So with that, this bill is really meant to have that conversation. And I think that we're starting that, and I'm glad to be doing that. Ultimately, what it might look like at the end, I don't know if it's even going to make it to the end. But I want to thank you for being here and starting that conversation with us and moving forward and talking about it more in depth. But I just want to be very clear that in no way does this committee believe that children should be taken out of the school environment unless it is best for those kids. And we need to determine how to figure that out. So thank you. That was really all I needed to say. So thank you very much, Mr. Chairman.
And I want to say thank you. Thank you for what you're doing, Representative Chairwoman Linehan. And there's nothing you just said that I disagree with.
Excellent. Good. We're moving forward then. Thank you very much, sir.
All right. With that, thank you so much for your testimony. And next I have is Yaz Leo, followed by Donna Kosirowski. Ms. Leo.
Hello, my name is Yaz Liao, and I'm a student at Yale University. I'm testifying today to communicate my strong support for HB 5243, an act concerning adult sexual misconduct. Sexual misconduct in schools has been historically underreported, mainly due to the bystander effect and a lack of intervention awareness. Preparing schools to handle cases of sexual misconduct efficiently and effectively is key for the health and safety of our students. While effectively reporting sexual misconduct cannot minimize its occurrence, policies that hold sex offenders accountable can. By setting standards for investigating abuse and potential abusers and removing offenders from the school system entirely, these measures would help prevent sexual misconduct before it even occurs. As it stands, the majority of abuse cases are never reported to authorities, and up to 66% of educators do not have specific training in child sexual abuse. Darkness to Light, a nonprofit organization against child sexual abuse, offered a child sexual abuse intervention program, Stewards of Children, to 79,544 educators in Texas. The year following training, educators reported child sexual abuse to authorities at a rate 283% higher than the previous year, indicating that training improved educators' competency in handling cases of child sexual abuse. K-12 students often do not receive training on how to report a sexual assault, and as a result might not know who to tell. bystander programs for students dispel myths about rape, change attitudes towards rape, and foster responsibility for intervening, and provide tactics and skills for taking action. The information can be delivered in a single brief training session and has significant effects on intervention 1 to 4 months after the program. That being said, the effects are no longer significant 6 months post-program, so booster sessions may be necessary. 1 in 10 children are sexually abused in the US before age 18, more than 50% of whom are abused before age 12. Sexual abuse affects children's ability to perform in the classroom. Sexually abused children perform worse on psychometric tests that measure academic achievement, memory, and cognitive ability. 51% to 79% of sexually abused children exhibit psychological symptoms such as post-traumatic stress disorder, anxiety, depression, and suicidal ideation. 60% of sexually abused children do not disclose, though children who receive effective treatment and support from an adult can recover without long-term effects. In conclusion, I urge you to keep our children safe from sexual misconduct. Nobody, especially not a child, should be a victim of sexual misconduct, and bystanders only perpetuate the problem. The ability to remove sex offenders from the education system and turn bystanders into active, competent reporters of sexual misconduct rests in your hands. I urge you to favorably vote this bill out of the Committee on Children so that our children can stay safe and healthy in schools. Thank you for your time.
Thank you, Ms. Leo. Thank you for your testimony. Can I ask you a question? What is your major at Yale?
Comparative literature.
Okay, you did a great job. And thank you so much for standing up and making sure you're lending your voice and strengthening the voice to protect our children. So truly appreciate it. Seeing no other questions or comments, thank you again for your testimony. We'll move on to the next person on our list, which is Donna Kosierowski, followed by Kimberly Prasad.
Good evening. Can you hear me?
Very well. We can't see
Okay.
you, but we can hear you.
Okay, thank you. My name is Donna Kosierowski, and I am the interim president of the Association of School Nurses of Connecticut and also the co-chair of the School Nurse Advisory Council. I would like to thank Senator Anwar, Representative Linehan, and members of the committee for the opportunity to speak to you on HB 5244, which is an act concerning the provision of opioid antagonists in schools. For purposes of simplicity, I'm going to refer to it as Narcan. I have submitted some written testimony and have outlined some questions, which I don't expect you to answer now, but I do have some questions about the funding and also if staff would be voluntarily able to participate in the training. I appreciate Representative Linehan for talking about SBIRT. It's new to me, the concept, and originally when I did my research, I was going to comment that I believe it's outside the scope of the school system, because what I learned is it assesses the severity of substance abuse and it determines the level of treatment, which I think is outside the scope of school staff. So Representative Linehan, I know it's probably not appropriate to talk about it now, but I would love to talk to you about that some more so I could learn whether it's appropriate for us or not. I think training for school staff should certainly focus on the use of Narcan, when you should administer it, how to administer it, and definitely the follow-up, because there are side effects and some people will have some negative effects when they actually come back to us. Training from the legislation that I can see comes from a medical provider or a school nurse, and I believe that the school nurse is probably going to be the one to do the training. I would like the opportunity to tell you that HB 5244, as well as legislation over the years, has increased the role of the school nurse. And we certainly have highlighted their contribution over the past 2 years in terms of their role in taking on a leadership role with COVID. I would like to share with you, if you don't already know, that qualifications for school nurses were written in 1982. We're celebrating our 40th anniversary this year in 2022, and nothing has changed since 1982. So I beseech you to please and respectfully ask that I think it's time to change that. I also want to take the opportunity to recognize Senator Kelly because he happens to be my senator, and Senator Kelly will be talking soon about that. So thank you again for the opportunity to speak to the bill. I think the bill is a good one. Our only concerns are about funding, because I heard a previous speaker say that the doses are $20 per dose. And some of my school nurse resources have told me that they can pay anywhere between $50 to $150 for 2 doses. Some of the Narcan is available free, but the amount of it is not infinite. So when it runs out, you can't get any free Narcan. Fortunately, in the district that I was in, we did have Narcan in our schools and we have not had to use it. But I have read about that 13-year-old and another 16-year-old who actually had a positive outcome because he did receive Narcan. And the other thing that I do want to say is that some of the reading that I've done indicates that maybe the doses of Narcan might be necessary to increase them, because some of the drugs are becoming beyond the ability of our current doses of Narcan to handle. So again, I thank you very much for the opportunity to speak to you on behalf of this. And again, Representative Linehan, I would love to be able to speak to you at another time about SBIRT, because I really would like to learn about that.
Thank you so much, Ms. Kozarowski. Thank you for waiting for a long time for your testimony and having a very meaningful testimony, and congratulations on the 40 years of the work that school nurses have been doing, and the scope of your work has been increasing exponentially, and the challenges across the state for what the school nurses do has been increasing exponentially as well.
If I may, Senator Anwar, just to clarify, 40 years ago, the qualifications for school nurses were written, and they're still on the books.
Yes, which is what I was going to come to, is that as your scope is expanding, it's time for us to recognize that and make sure that we keep up with the times. So this is a conversation maybe the two of us or Senator Kelly and I can have at a later time as well. But thank you for your testimony. I know 2 of my colleagues have questions. I will start with my co-chair, Representative Linehan.
Thank you very much, Mr. Co-Chair. And I want to thank you for being here. And I know that Senator Kelly, who is speaking after me, is probably going to ask you a lot of questions regarding the other points of the bill. So I just want to address the one thing that you talked about towards me, was the adolescent SBIRT program. The adolescent SBIRT program is actually not outside your scope. And in fact, I've utilized this program often. We put forth a pilot program in the town of Cheshire where we trained school employees, teachers, we trained firefighters, police officers, and we were also able to provide it at the Cheshire Public Library to train anyone who has a relationship with a child where they might have a concern. So it's absolutely not outside your scope. I don't know if the regular SBIRT program is a little bit deeper, but there's an adolescent program and then there's a youth program. And so those might be just like a little bit less clinical, but no worries there, but I would still I would be happy to talk to you further offline.
Okay, or if you could give me a link or something so I could do some research before we talk, I'd appreciate that. Thank you.
Sure, absolutely. So thank you very much. And thank you, Mr. Co-Chair.
Thank you, Senator Kelly.
Hi, Senator Kelly.
Hello, Donna. How are you today?
I'm good. How are you?
I'm well. Thank you. I wanted to just come on and first of all, thank you for your years of service as a school nurse. And then also for your years of service as a representative of those school nurses at the Capitol, advancing the cause. It goes without saying that school nurses are an essential and necessary part of our school system. And we need to really focus on it. I heard what you said today about the topic that we're dealing with, but I also wanted to let you know that I do hear.
Hey everyone, it's been a while. Well, it is the first day of a new month.
I do hear modern technology, that I do hear the issue with regards to school nurses. I know that in our town of Stratford, that the school nurses are in the same bargaining unit with secretaries and janitors. And I think that we need to look at them as the professionals that they are and the critical, important, and essential services that they provide to our children to make sure that their educational environment is healthy and safe. So thank you for your advocacy. Keep up the good work. It is being heard, and I look forward to continuing the dialogue.
I'm going to call you. I'll be calling you. Thank you.
Take care.
Thank you very much, everybody.
Thank you for your testimony, and we see no other comments. We'll move on to our next person on the list, which is Kimberly Prasad, followed by Sarah Odell. Ms. Prasad.
Good evening, members of the Committee on Children. My name is Kimberly Prasad, and I'm a resident of Hartford and a current Master of Social Work student at the University of Connecticut School of Social Work. I'm also a current intern with the Department of Children and Families in Hartford. I'm testifying today in support of the Raise Bill number 205, an act establishing a Children's Mental Health Day in Connecticut. I believe it is important that the state of Connecticut recognizes children's mental health and creates awareness around the positive effects that being outdoors has. Interning at DCF and working in my community, I witnessed the benefits there are for children being outdoors and staying active. This opportunity builds resilience in children and leads them to have a balanced and healthy life in school and in the communities. While I support this bill, it would be more beneficial to expand mental health services in schools, such as hiring more therapists, social workers, and applied behavior analysts. This strengthens the bill and allows children to receive mental health services throughout the school year in addition to this day dedicated to mental health. Expanding mental health services in schools creates more awareness and education around children's mental health than solely dedicating one day out of the year. This is also beneficial because these workers can work closely with the children and provide one-on-one support. This expansion, in addition to establishing a Children's Mental Health Day, will be beneficial for parents who are low income and have difficulty accessing mental health services. These additional workers can work with parents and build a personal connection and rapport to educate them on preventative cares and efforts and work with them to refer them to additional resources if needed. With the expansion of mental health services in schools and the Children's Mental Health Day, this will bring positive effects on children's mental health and provide more awareness to parents who struggle with finding resources for their children. Thank you for your time and the opportunity to testify today.
Thank you so much for your testimony, Ms. Prasad, and congratulations on moving towards your social work training. And we're so glad you're working with our DCF. They do an amazing job. So hopefully this would be a very useful experience. Seeing other comments or questions, we will move on to the next person on our list, which is Sarah Odell, followed by Crystal Rich. Ms. Odell. I'm not seeing Ms. Odell here, so we will jump on to the next person on the list, Crystal Rich, and then if Ms. Odell comes in, we will have her speak after that. So Crystal Rich, you're on. We cannot hear you yet, Crystal. Yeah, I think you're having difficulty with your audio. I can. Okay,
can you hear
me
ahead. Now?
Very well. We can't see you, but we can hear you. Oh, there you are.
How's that?
Excellent.
Okay, great. Thank you. Good evening, Senator Anwar, Representative Linehan, Senator Kelly, Representative DeFinier, and distinguished members of the Committee on Children. My name is Crystal Rich, and I am the Executive Director of the Connecticut Children's Alliance. The Connecticut Children's Alliance is the state's coalition for the 10 child advocacy centers and 17 multidisciplinary teams charged with providing a comprehensive and collaborative response to the approximate 2,000 child victims of abuse they serve each year through joint investigations, advocacy, evidence-based mental health treatment, specialized forensic medical exams, child-focused forensic interviewing, and support for caregivers. CCA also serves as the umbrella organization for the Prevent Child Abuse Connecticut chapter. I provided written testimony in support of several bills on today's agenda, but I'd like to focus my time now on HB 5243, an act concerning adult sexual misconduct, specifically Section 10. I want to start by saying that we fully support the spirit behind this bill and really appreciate the committee's dedication to address this ongoing issue and clear commitment to keeping our children safe. Section 10 is already mentioned by others. When we read the language, we had some concerns regarding the investigation component. We fully agree that further standardization of how schools and child serving programs handle information regarding potential abuse and neglect is absolutely needed. But our concern is that the fact finding of school personnel and child care providers could lead to an unintended interview of a child by someone not trained to provide the specialized service. Currently, not only is DCF statutorily mandated to investigate these cases with the assistance of law enforcement, but in addition, as outlined in the general statute, our state practice is to refer cases of suspected child sexual abuse to one of our Connecticut's 17 multidisciplinary teams for a comprehensive response that includes the investigative partners and service providers. When there is a suspected case of child sexual abuse, DCF and law enforcement are asked to refer the child victim to one of our 10 child advocacy centers to receive a one-time forensic interview. During these interviews, both investigative partners are able to watch the interview while a specially trained forensic interviewer talks with the child in a neutral, fact-finding, non-leading way to gather the information needed by investigative partners. This process also helps to ensure that we reduce the number of times a child is asked to retell their story and helps providers identify appropriate services. We ask the committee that any protocols developed take into consideration the full multidisciplinary approach and are developed with the input from representation of each of the MDT partner disciplines. We also just want to comment on the minimal facts training mentioned by the commissioner earlier. That training was developed by the Governor's Task Force on Justice for Abused Children in collaboration with DCF and has been provided to schools and community providers as an almost secondary how-to to the state's mandated reporter training. I too agree that this could be a helpful process and good starting point to fulfill the intention of this section. I would recommend that there be several updates to the current curriculum in order to meet this need. And would be happy to share in more detail some of the successes and challenges we've had as a partner in doing the minimal facts training. And I'd be happy to offer any support in any way we can. Again, we are thrilled to see the amount of focus on this topic, and I thank you for your time, and I'm happy to answer any questions.
Thank you, Ms. Rich, for your testimony. Thank you for waiting for a long time today.
No
and we
problem.
truly appreciate your testimony. And I think you have a written testimony as well, right?
Yes.
Perfect. Perfect. We will go over that and we will reach out to you for more insight. Thank you so much. And seeing no other questions or comments, we'll move on to the next person on our list, which is Dr. Craig Allen, followed by Rue Powell. Dr. Allen.
Hello. Thank you. Good evening. I guess it's good evening now. Senator Anwar, Representative Linehan, and members of the Children's Committee. I am Dr. Craig Allen, Medical Director of Rushford, Chief of Psychiatry, Mid-State Medical Center, Vice President of Addiction Services for the Behavioral Health Network of Hartford Healthcare. Thanks for the opportunity to speak this evening in support of House Bill 5244, an act concerning the provision of opioid antagonists in schools. I submitted a written testimony, so I'm not going to read that. I'll go off of that a little bit. I was part of a panel on January 17th, addressing over 200 parents, understandably anxious and concerned. They're from the Sports and Medical Sciences Academy in Hartford. A few days earlier, the community experienced the tragic death of a 13-year-old from fentanyl poisoning. Many of the parents in the audience didn't know about the opioid overdose epidemic before and during COVID. They didn't know that opioids and fentanyl were the drivers behind the leading cause of death for people in the United States under the age of 50. Many didn't know the ubiquitous nature and easy access to fentanyl, a drug which 50 times more potent than heroin, can be lethal if snorted, smoked, injected. Many of them didn't know that in communities of Hispanic and non-Hispanic Blacks, the rates of opioid overdose death had been skyrocketing in the state of Connecticut. And many didn't know that there was an antidote available, an antidote for the poisoning, naloxone, a drug safer than aspirin or acetaminophen or over-the-counter cold medications available through the pharmacy, through their doctor, through harm reduction agencies. And certainly many of them didn't know, but we heard about it here tonight, that for a number of years, schools across Connecticut, a number of different schools have had training in identifying opioid overdose signs and symptoms and in using naloxone and have had naloxone on site. Many of the parents had never heard of SBIRT. We've heard of SBIRT and talked a little bit about it already. That's the screening, brief intervention, referral to treatment, which is an evidence-based tool to identify kids who are at high risk to use substances. And if kids are using substances, can identify kids who need more help and can be linked to care. I doubt any of them knew that this program had been piloted in the state of Connecticut, beginning with the American Academy of Child and Adolescent Connecticut chapter back in 2015. We know all this. We know this information now. And as a child and adolescent psychiatrist and addiction medicine doctor, as a parent and as a member of the community, I strongly encourage you to support House Bill 5244. I'm happy to answer any questions. I'd love to talk to Donna about SBIRT if she doesn't get her questions answered, and also about naloxone. But thank you for the opportunity to testify today.
Thank you so much, Dr. Allen. Thank you for waiting for a long time today, and appreciate your testimony and the work that you're doing. I wanted to ask you a question, and I think you highlighted that about Narcan or naloxone being safer than aspirin. And I think there's all this fear every time we have this conversation. Somebody says, well, we don't know how to administer it and it can cause a negative impact. Can you just put more highlight on this and then clarify this for all of us?
Right. You know, if you haven't taken opioids, if you haven't used opioids, you will not notice any effect if you get naloxone. If you use it, there's the intranasal naloxone, which is the most popular form. It's the easiest to use. And we find that parents and families and people who are at risk are most comfortable with it. You know, in the state of New York, in the city of New York, they have, they're going ahead with vending machines with naloxone. So, you know, evidence that the safety of it. There have been many studies done on naloxone. Some people fear that if naloxone is available in communities, it might lead to people experimenting with drugs, but the contrary has been seen in study after study, that when naloxone is available, it decreases the opioid overdose deaths, and it increases the number of people who actually get into treatment. You know, and we always use the term, you know, you can't get into treatment if you're dead, and naloxone saves lives. And the more people that carry naloxone, the better off we're all going to be. You're much more likely to come across somebody who has overdosed from opioids than you are someone who's had a cardiac arrest. And we're very comfortable with AEDs. We're very comfortable learning how to do CPR for a cardiac arrest. This is much easier to do. And there's no negative ramifications if the person hasn't used opioids. And if they have, and their breathing is impaired, you can save a life.
Excellent. And if you would not mind, offline, I'd like to reach out to you. There are some thoughts about our Public Health Committee has a bill on opioids that I may need your insight on for the opioid related challenges that we are seeing, and especially for some of the new synthetic things that are there, unless you want to mention about some of the synthetic chemicals that are out beyond fentanyl at this time.
Right. You know, and the thing with these synthetic medications, many of them were, well, the fentanyl that we're talking about isn't fentanyl that is used in the medical community. The fentanyl we're talking about is made in these basement labs, probably coming in from China and Mexico. Most of it, it's easy to transport. And we heard about it earlier today. It's just, you know, it's few number of grains can lead to a serious death. But the more potent, the easier that they can be made and they can be transported across state lines, the greater risk that that we all have. But there are some fallacies about fentanyl. You should use gloves. You should be careful if you think it's around, but it doesn't go through somebody's skin. And really, there hasn't been a case in the United States where it's been documented that personnel, rescue personnel, police personnel, first responders have actually been harmed, although that's debatable. So I say that because you should not hesitate to help somebody. You shouldn't worry to give them respiratory support, CPR, certainly naloxone, because you're afraid that you might be contaminated with the fentanyl. We haven't seen that happen. So just something to put out there. But these really potent synthetic opioids are very scary. And when I talk to families and I talk to kids, there was a time when kids' brains are made to experiment new and novel things, right? And so growing up, many of us have maybe drank alcohol before you were of age or used marijuana or something, and you have the natural repercussions. You might be sick, you might go to the hospital, you might lose use of certain different advantages your parents would give you, no allowance. But these days the repercussions can be death. And it's terrible. It was terrible and tragic to see what happened in Hartford. We're all saddened by that, but we really shouldn't be surprised with the amount of synthetic opioid that is available in the community. It's laced into other drugs, as you guys have probably heard, these fake pill presses and so forth. So it's around. You have to be super careful. It's not like 20, 30, 40 years ago.
Thank you so much. And I know one of my colleagues has a question, Representative Comey.
Hi, thank you so much, Doctor. My question is, in your testimony, you really talked about everything that the parents and that what they didn't know, right? Do you think that, we need to do a better job of educating people on the presence of it in our communities, and can you talk to that?
Yeah, absolutely, positively, we need to do a better job. There's been so much going on. I know you've noticed COVID. There's so many things that we're distracted by, but this has been going on for a very long time. The opioid, the term is overdose, but really, I think technically we're talking about poisoning, the opioid poisonings across the country. The more information we have, information is power. If parents were aware that naloxone existed, if parents understood that Esper, which we heard earlier, can be used by lay people with little training, with some training, but to identify people at high risk. If parents knew that, would they not be clamoring for it in their schools? I'm a parent, and I want it. I want it in my kids' schools, both screening, brief intervention, education. And then, naloxone isn't treatment, but it can save somebody's life. And we also need to have treatment available. And that's in a woeful state in the United States too. The Surgeon General came out with an advisory in December of 2021, and you might have seen it, where he talks about the challenges before COVID, and then talks about how they've been exacerbated with anxiety and depression in our adolescents, and really a lack of training and a lack of communication, really fractured treatment programs, and lack of beds. You guys have probably heard that, and the number of people in the emergency rooms over at Children's Hospital in Hartford from time to time really can be overwhelming. And we need to take a look at the whole system and make sure that we have the services available for our children, because they're our future.
Absolutely. Thank you so much, Dr. Allen. Thank you for your testimony. Seeing no other comments or questions, we want to thank you, and I will try and reach out to you later.
Thank
The
you.
next person on the list is Rue Powell, followed by Sarah Odell. And first we will take Ms. Powell, and followed by Ms. Odell.
Hello, thank you so much for the opportunity to speak. I'm speaking on House Bill number 5242, the Act establishing an online sexual abuse and exploitation task force. My name is Rue Powell. I'm the founder of a nonprofit called SOSA. It stands for Safe from Online Sex Abuse. SOSA works to end the online sex abuse and exploitation of minors. We do this in a number of ways, including providing online safety education for youth, providing education for parents and caregivers and schools, and we use decoys in the study of grooming patterns to identify online predators for law enforcement. Our work at SOSA has resulted in arrests and subsequent adjudication of people who abuse minors online in a number of ways. This can look like one-on-one abuse for personal gratification, the creation and distribution of CSAM, which stands for Child Sex Abuse Material, historically referred to as child pornography, and intent to be a hands-on abuser. At SOSA, we have worked with law enforcement at the federal, state, and local levels, and what we have found is that some states adopt laws that better protect children online. I'm hoping that House Bill number 5242 can explore how it can be applicable to Connecticut. Smartphones have only been ubiquitous in the past decade or so. Snapchat's only been around for a decade, which means that today's kids are the first generation of kids who have had such open access to the outside world, and vice versa. So when we were all younger, our parents were perhaps only worried about bad actors that were in close proximity to us. But now a child does not have to be in the same room or town or state in order to be abused by a predator. And so with the advent of new technology comes new avenues with which to abuse children, and subsequently requires a response that protects children. Too frequently, society resorts to victim blaming without really understanding the issue at hand. Online abuse is pervasive, and online predators are incredibly manipulative and coercive. And I know we all care about child safety and well-being. A task force would allow for people in Connecticut to see the breadth of what happens in the state and respond accordingly.
Thank you for your testimony, and thank you for the work that you do. I see Representative Wiellander has a question.
Thank you, Mr. Chair, and thank you for what you do, Rue. I was wondering if you could speak. One of the goals of this legislation is to identify not only the prevalence and the unfortunate, I think, the growth and the increase of online abuse towards our children, but it's also to identify some of the reasons why Connecticut in particular may not be able to hold those who are doing this predatory behavior accountable. Do you think that being able to identify that this task force would be helpful in identifying those reasons and could potentially lead to more prosecution of the offenders?
I do. I think a lot of it has to do with there being such nuance around each law. And so I think that a lot of these perpetrators know when they're breaking the law and when they're not. And unfortunately, a predator can be abusive without ever breaking the law. In other states, there are different grooming statutes enacted in order to prevent that from happening. But there are so many loopholes when it comes to online abuse that it makes it, I don't want to say easy, but it makes it hard to catch or prosecute someone when they're not necessarily breaking the law, but they're acting abusive in nature in a way that is harmful to children, but they haven't crossed a specific line. I also think that law enforcement groups law enforcement agencies and task forces that combat internet crimes against children are under-resourced. And because this is new, and because there's just this influx of online abuse, there just isn't the amount of people power to fight it. So I do think that because maybe society as a whole hasn't quite wrapped our collective head around what online abuse is, a task force could be really beneficial in sort of spelling out what happens online. And once we can really collectively, get our head around what happens, and we can come up with a solution.
Thank you so much for that. I really appreciate it. Your insight and your work and taking the time to be here with us tonight.
Thank you.
Thank you so much for your testimony. Seeing no other comments or questions, thank you for your time today. We'll move on to our next speaker, which is Sarah Odell, followed by Dr. Daniel Karekes. Hi, Ms. Odell, sorry we had you wait today.
Oh, sorry, my cuckoo clock's going off. I'm sorry. Hold on 1 second. Okay. Sorry, hold on.
It'll go on for 6 times.
I apologize for not being here earlier. My daughter was at an Irish dance class, and we do not get reception in the Irish dance parking lot. So my name is Sarah Odell. Thank you so much for having testimony today. I'm the Vice President of Government Relations for the Connecticut Parent-Teacher Association, or Connecticut PTA. And I represent the Connecticut PTA and its over 30,000 members regarding SB 208, an act concerning social media and parental consent. Connecticut PTA supports this bill requiring parental consent to open a social media account prior to age 16. While social media has been a force for good in so many important ways, there's obviously a significant dark side, as we all know. And in fact, if you've recently spent any time on your town's local Facebook group, many adults have challenges navigating platforms with kindness, honesty, and civic responsibility. And so it can be an incredibly heavy lift for children, almost impossible, really. Now, platforms requiring kids to be 13 to open an account without parental consent. A recent study on kids opening accounts showed that a third of kids admitted in a survey that they already had social media accounts on things like Snapchat as young as age 11. And with their developing brains, they're typically not ready for the challenges of good online citizenship. I think that I heard in earlier testimony a lot of important dialogue about how to make this happen and ways to make it happen. The Connecticut PTA's concern with social media goes beyond the initial headlines. We are especially urging lawmakers to remember that if the product is free, then you are the product. And that means that children as young as 13, no longer protected by COPPA, will become the product and their personal information collected and sold to advertisers of everything from shampoo to political ads. So establishing age 16 as the age before which children need parental consent will encourage joining platforms at a later age for many, certainly not all. But we are very hopeful that establishing that rule will call parents of children under 16 into the conversation with their children, helping them actively engage with their children's online behavior. So we urge your support of the bill. Thank you.
If the product is free, you are the product. I love it. I'm going to use it. It's beautiful. Beautiful. Thank you for your testimony. Truly appreciate the work that the PTAs do thanklessly for in so many ways. And we truly appreciate your support of this bill. This is a very important bill in my opinion, with respect to at least starting the process and beginning this challenge of the difficulty that we have. I know one of my colleagues, Representative Wheeler, has a question for you.
Yes, great.
Dr. Wheeler.
It's actually more of a comment. I just wanted to say, as a former PTA president, I really, really appreciate what everyone does for our schools and their focus on the safety for our students. So thank you for taking the time to be here today.
Thank you. I think you're going to see more of me. We're definitely working to increase our presence at all these committees. I know that my predecessor in this role, Judy, was often here speaking to you guys and the other committees about the concerns of our membership. We're hoping to really have some of our members join you and speak their testimony as well as we go through this session and into the future. So thank you so much.
Thank you.
Thank you. And seeing no other comments or questions, we will move on to the next person. That's Dr. Daniel Karekes, followed by Roha Yusuf. So Dr. Karekes, I hope I did not mess up last name.
No, that was perfect. Karekes is right. Distinguished members of the Joint Committee on Children, thank you for allowing me the opportunity to speak today. I'll be speaking in support of House Bill 5244, an act concerning the provision of opioid antagonists in schools. My name is Dr. Dan Karakis. I'm currently a resident physician in training in general surgery in Connecticut, a role that sees me prescribing opioids both in and out of the hospital on an almost daily basis to help patients get through post-surgical pain. Prior to moving to Connecticut, I attended medical school in Baltimore, where I was an opioid overdose response and education trainer. And in that capacity, I taught medical professionals, graduate students, and Baltimore community members how to recognize opioid overdose and respond to it appropriately with opioid antagonists. During community sessions, I heard stories from young attendees of trying to save overdosing friends, often with milk or orange juice or splashes of cold water. And then after a few slides and a brief discussion, these young attendees would leave the training with naloxone and with knowledge in hand about how to help in the future. Unfortunately, as we've established today, opioids are everywhere and they are leaving their mark on all age groups. I also submitted written testimony outlining the grim state of affairs. But to highlight some of the more striking statistics, in 2017, 769,000 US children aged 12 to 17 misused opioids, with 14,000 having used heroin in the last year. Furthermore, nearly 3 times that number, over 2 million kids used illicit drugs of some kind, and due to widespread and increasing contamination with fentanyl, they are also at risk for opioid overdose. And moreover, the epidemic is getting worse, not better. 2021 was actually the worst year on record for opioid overdoses in the US, with over 75,000 reported. According to a 2020 CDC survey, 13% of all those surveyed started for the first time or increased prior substance use to help deal with stress related to COVID-19. And so the time to act is now. And there is some good news, and that's unlike many conditions in medicine for opioid overdose. There is an extremely effective, extremely safe, and extremely cheap cure for this killer of kids. Naloxone immediately halts the effects of opioids and has the power to quite literally restore breath within seconds to a child who has stopped breathing due to opioid overdose. A child who cannot help themselves and who is relying on a bystander, whether they are at a friend's house or at school, to save them in the 5 minutes before brain damage sets in. Naloxone, it's easily administered, and it has no effect on somebody who is not on opioids. And providing naloxone to schools and empowering employees to respond to overdoses can save the lives of Connecticut children at low cost and low risk. And so I strongly urge you to adopt House Bill 5244. And on the tail of previous discussions today, I would encourage the language of the bill to make school funding for naloxone as easily attainable as possible with as few obstacles. And thank you for all that you do. I invite any questions, and I'm also happy to make myself available for other opioid epidemic bills in any way that I can help. Thank you.
Thank you so much, Dr. Karakis, for your testimony. Appreciate it. And we will take you up on the opioid part as well. And then please connect with me after this. Would love to talk more. And it's great to see a surgeon involved in some of the policy work. I love it. Good to see you.
Thank you very much.
Seeing no questions, no comments, we'll move on to the next speaker, which is Roha Youssef, followed by Officer Mark Suda. So, Ms. Youssef.
Hi, Representative Linehan, Senator Anwar, and the members of the Children's Committee, including the Vice Chair and Ranking Members. My name is Roja Youssef, and I represent the Center for Youth Leadership in Brian McMahon High School in Norwalk. I am testifying in support of House Bill 5239 about English language learners. We have 2 comments. You may want to revise the bill to make sure that all ELL students are offered extra time on state-issued exams like the SAT and subject-related tests. According to the ELL teachers we consulted, in some school districts, it is the responsibility of ELL students to ask for extra time on state-mandated assessments. We believe school counselors should tell ELL students of their right to extra time, with the student given the choice to accept or reject the offer. That leads to our second comment. For several years, our student group has led a project in which our bilingual members welcome ELL students to our school. They meet with them in our counselor's office first thing on their first day of school. They explain their class schedule to them, walk them around the building as they point out the best way to get to each of their classes, and show them how to set up their school lunch account and school-issued laptop. During their walk together around the building, our members also explained some of the rights that ELL students have. For example, the use of restrooms, reporting incidents of harassment, conduct during the playing of the national anthem, requesting tampons or pads, joining clubs, trying out for teams, and other topics. Our school district and ELL teachers routinely offer ELL students extra time on in-class exams and schoolwork, but the same cannot be said for the students' non-ELL teachers. That disconnect can be unsettling to some ELL students. Therefore, you may want to add to the bill a requirement that school counselors explain to ELL students their right to extra time, that it is within their rights to ask for it, and that all teachers must grant it. We need to keep it in mind that many ELL students, especially those from war-torn countries or those who survived violent treks to America, are battling mental health issues, including trauma. Schools should remove all of the barriers that prevent ELL students from succeeding academically and emotionally, and that work should start on their first day of school with an explanation of their rights from their school counselor. Thank you.
Thank you so much, Terima kasih, for your testimony. Truly appreciate it. This is very helpful and very important, and we appreciate that you speaking on this. Representative Wielander, you had a question or comment.
Just a comment on behalf of the Children's Committee. My chair reminded me, a practice that the committee has of making sure that students that testify are acknowledged by getting a special pin from the committee for taking the time and using your voice to advocate for things that are important to you. So our clerk, Jean, is going to be reaching out to get your home or your address that we can send something to you. So thank you for being here.
Thank you. Roja, keep up the good work. Thank you. And the next person, last but not the least, is Officer Mark Suda. Thank you, Officer, for your time today, and thank you for waiting for a long time. Appreciate you coming in.
Sure. Thank you guys for the opportunity to speak as well. So my name is Mark Suda. I'm an officer with the Norwalk Police Department. I've been there 29 years. Out of those 29 years, I've been in the Special Services Unit, which is pretty much a fancy name for narcotics, vice, and gangs. One of my functions is also to do human trafficking. And I'm here to talk about Bill 5242, establishing the task force for the online sexual kids task force. This is so important. I can't even tell you. In my 20 years of law enforcement in narcotics and gangs, I haven't seen what I saw. Last year, Rue Paul, who spoke to you maybe about 5 or 6 people ago, she forgot to mention. So I was contacted, and I was contacted to go meet Rue and her people at SOSA, her nonprofit based out of Milford, Connecticut. And this is pretty much what she does. I was contacted to do a show with her. And when the producers first called me and said, hey, we want you to come meet Rue, possibly do this show with her. It's on the Discovery Channel. It's on, actually it just came on Discovery ID last week. They showed the first 2 episodes. So if you guys want to see what we did and see what goes on, I tell you, you're only going to see not even 10% of what we saw and what we dealt with for 10 weeks. So the show is called Undercover Underage. It's on the Discovery ID channel. It airs every Thursday night at 9 o'clock. This Thursday coming up is episode 3. I believe you can go back and watch them. You can also stream it on Discovery. But in my 20 years in narcotics, gangs, and vice, what I saw in this 10 weeks having to do with how these sexual predators go online and not only the way they contact the kids, what they thought was a kid. So again, Rue poses as a 15-year-old female, and she has different personas in different states. And once she launched her persona, these guys would contact her within seconds, minutes. We've had 10, 20 people within 5 minutes. gentlemen that think that she's a 15-year-old girl, and what they did on FaceTime with her, on the computer, audio calls was absolutely unbearable. Wait till you guys need to watch this show. The reason why I'm speaking today about the show, so you guys can, it's a good way for you guys to see what happens. But what we saw happen in 10 weeks was just incredible. I'm speaking as a police officer now. I was a consultant on the show, but as a police officer, what I see in our special victims units or our youth bureaus, there's not enough resources. This with the phones and stuff, this is coming on so fast that these kids don't have a chance, unfortunately. And the way that these guys, these sexual predators manipulate and go on and attract these kids, it's unbelievable. It could be as easy as you say goodnight to your kids. It's 10 o'clock at night. You go in your bedroom with your wife or your husband. And next thing you know, in the next bedroom, your 14-year-old daughter or son, this just doesn't happen with females. It also happens with males, can be in the next room talking to these guys all night long. How we used to joke around when I was a kid. I'm 50 years old, but when I was a kid, you always see the crazy looking guy in the playground when you're on the swings. Now, what these sexual predators do, they use the internet and cell phones, tablets to establish their playground to pretty much prey on these kids. I'll pretty much leave it like that. The show's a good indicator on what you guys can see happens. But again, the resources to establish this task force and then to join with law enforcement and also nonprofits such as Rue's company, SOSA, to combat this problem, I think is a great start. And I strongly suggest that you guys approve Bill 5242.
Thank you so much, Officer Suda, for taking the time and waiting for speaking about this issue to all of us and all the people who are listening as well, and truly highlighting the dangers that are there that impact our children. So thank you for all that you do. It's such an important work. I have two of my colleagues' questions and comments. I wanted to start with Representative Dauphinée.
Sure.
Thank you, Senator, and thank you, Officer, for all the work that you're doing with this. We know it's a huge problem, not only in Connecticut, but across the nation. But I just wanted, could you please be a little bit more detailed again about the show? I would like to watch it. So what is it called and when is it on and where can we find it?
Sure. So you guys can go on to, if you go on Discovery Streaming, you could go right on their app. And it's on Discovery Plus. That, I think it's a $4.99 fee, but the good thing is you get like a 10-day free trial.
Okay.
So you can actually binge watch all the shows. On there, you can watch all 6 episodes. There's no commercials. They're only 42-minute long shows. So that's Discovery Plus, and the show's name is Undercover Underage, and it's myself and Rue. I pose as like her Uber driver at times. You'll see it's very interesting. And my job for the show was to pretty much gather because I was a consultant, gather all the intelligence and intel and provide it to law enforcement in each respective town or state or city. But again, Undercover Underage. And then on regular TV, it started last Thursday, and kind of episode 1 and 2 go together. So they showed them back to back. But I believe you can go on and watch them. But this Thursday at 9 o'clock, it's Undercover Underage, 9 o'clock on the Discovery ID channel. I know down my way in Fairfield County, it's channel 171 on Cablevision or Altice, whatever it is down here. But everybody has the Discovery ID channel.
Thank you. I thank you for all the work that you're doing, and we appreciate your testimony.
Thank you.
Thank you, Representative Wiellander.
Thank you, Mr. Chair. And thank you, Detective, for everything that you did and continue to do. There were just a couple points I wanted to mention. And I will say that I agree that the show does put some of these issues into perspective if you are able to, but I think we can all agree are able to watch it. But I think we all we can understand without watching it how horrific some of these online actions are against our kids. But I wanted just to mention that thank you for mentioning that this online predation and abuse happens to both boys and girls, that this is a unfortunate thing that happens across all genders, and also mentioning the need for more staffing. And that is one of the main goals of the legislation, is to identify where do we need more staffing on law enforcement, and in such a rapidly changing field. And I think you alluded to that, and that this is something that it's changing the face of child abuse in a really quick way. Is there any other concern from your perspective in law enforcement that you would see as being a bigger challenge for another challenge for prosecuting some of these offenders or people who are doing this abuse against our children?
So this was tough, especially with the show. I mean, again, this isn't my field, but with the show, again, gathering all the intelligence and on these individuals and trying to ID them to give them to law enforcement. The biggest issues are what we found in the other states. They were welcoming. They were like, bring the case to us. We can use you and Rue kind of as informants, and we can feed off. Then they can take over the investigation and or put in place one of their detectives that is trained. So there's no entrapment. That's the word I'm looking for. So the other states were open arms, welcoming. Connecticut was tough because we don't have a grooming law. So just to start, I mean, just by what some of these guys are doing, that would enable us to get a search warrant. Once we get a search warrant, then we can go in and we can go search all the guys' tablets, phones, computers at home, any electronics. And once we do that, and then we go back, we can do our investigation. But again, in Connecticut, the grooming law isn't there, and the staffing really isn't there. So, like you said, this is coming on rapidly, and it's crazy what these guys are doing, and what they know the laws right now, and they know what to get away with, or what to do, and what they can get away with. So I think by starting a grooming law, and or this task force where law enforcement can work with this task force, can work with the legislators to make these new laws, give a lot of input.
Marty,
the nonprofits. I think that's a great start to combat this problem.
Thank you so much for that. And I just want to reassure you that I actually have been working with the Judiciary Committee to strengthen the language that we have in our statutes about grooming and online exploitation, because I agree that I think there needs to be some strengthening in making sure we can keep our kids safe. So thank you for your time. It looks like our chair has stepped away for just a minute. But
I just have to take a quick little phone call, actually, but I wanted to thank you for your testimony. I truly appreciate your testimony and the work that you do. Appreciate you so much.
Anytime.
Thank you. And you are our last speaker. Seeing no other comments or any questions, we will thank you for your testimony. And everyone, thank you so much for being here today and listening through these very difficult conversations. And with that, we will adjourn. Thank you.